on that, the recommendation might be on the, oh, they couldn't hear us from, now they can extra hear us. That section not be included in the ultimate recommendation to the group, right? That's an important stakeholder, and if there's some resistance or opposition to those provisions, that's likely to be something that our office recommends, and ultimately Group 5, recommends, be excluded from the comprehensive recommendation. Keeping our fingers crossed, hoping that that will break a different direction. We'll at least do obviously formatting changes and renumbering so that section plugs in right the way where it should, and the rest of it. But some of those substantive changes to align current practice with what the charter says, because they were misaligned, are potentially not going to be part of the ultimate recommendation. Those were quick and presentations on 1, 3, and 5. Mr. Chair, I'd be remiss if I didn't ask if any of the members of groups 1, 3, or 5 wanted to supplement that report out as part of the report out to the group today.
I see none.
Very good. Next slide is the kind of the transition to the much more substantive and detailed report outs that's the focus of tonight's meeting from groups 2, 4, and 6. The language really for all groups, but particularly for 2, 4, and 6 has been developed over multiple meetings, including stakeholder input. As you all know, there has also been throughout this process report outs monthly to the full CRC that were designed to keep the CRC and the public aware of the issues that were being discussed, at the subcommittee level. And the presentation tonight for groups 2, 4, and 6 is really a culmination of those efforts, with a few caveats on certain issues that I'll identify and members of the group, may identify as we go through this. But the culmination of the efforts to solicit the full CRC, input and direction. The idea is that after that exercise, if the CRC is comfortable with one or more of these groups reporting out in this comprehensive way, the direction would be to finalize those terms, and bring it back ultimately to this group when you all meet for your final, recommendation to the City Council. So tonight is intended to be the next step on the path towards some of the subcommittee groups, reaching the final recommendation to be included in this group's larger recommendation. Currently, we're working on identifying another meeting for the CRC group in early June. And we'll talk later about how that aligns with the schedule that we're developing with the City Council. We may be able to present, at least in a workshop format, to the City Council as early as June 9th. And we've actually got a space reserved on the June 9th, agenda. So we'll talk about that later. There are still issues, as you might, any of you have seen, particularly the ones who are reading this extra carefully, and I thank you all for that. There are still, I'm sure, issues with grammar and typos and consistency and cross-references and formatting. All of that's still under internal review by our office, and I think by any of you, because I'm getting a lot of good corrections from folks, either just separately in email communications or at the subcommittee meetings. So please don't think, even though this is a substantial report out, hey, tell me what you think, that process isn't ongoing and won't be ongoing up until the point where the language is presented to the City Council. So with that, Any question on the nature of what's happening tonight with groups 2, 4, and 6 before I dive in, deputized by all the groups to lead the presentation, starting with group 2? Very good. Thank you, Mr. Chair. So group 2, it was assigned the sections of the charter dealing with the city council, elections, powers, and conduct of meetings. Unfortunately, as you all know, somewhat awkwardly conduct of meetings, because conduct of meetings was really divided in the charter between groups 1 and groups 2, and that's all coming together. Group 2 met a number of times, 1, 2, 3, 4, 5, 6 meetings, most recently May 7th, and stakeholder input at various times throughout those meetings was received from the city clerk's office, recently from the chief of police that I passed along, and from the city manager's office. But the city clerk really being kind of at the forefront of those sections, given the nature of those sections. So on this next slide, let me back up a little bit to characterize kind of what these changes are and how they're being presented. You all received, and it's also been uploaded to this item in the on the agenda, and therefore available to the public. I'm sorry, library's closing, so Mr. Chair, we're going to have to end this meeting a little early. No, I've been assured, thank you, by library staff that we have a special dispensation. Yeah, no motions to adjourn. Don't be that excited. This draft that I'm holding up, here, is a draft that both identifies all the different committees, in the first, sheet with the names of the folks involved, and the responsibilities, has a color-coded version of all the different sections, so you all are reminded and the public can see, how the charter was broken up and how it was assigned, and then ultimately a clean version, of what's being, proposed and recommended. You all have a underlined strikeout version. Ultimately, an underlined strikeout version, once this is in more final form, will of course be made available to the public as well. But right now, the underlined strikeout version has a lot of annotations in it and kind of internal comments that we want to get out, of that or resolve before that version as well is presented to the public. But no matter what, the public has at least this version, the working draft, the clean working draft, version of the document. And I'm going to be referring, to that, tonight in order to highlight, the proposed changes that are being made in the various sections. If you have a clean version of the charter or the underlying strikeout version, which was also sent to you, electronically, you could also, look at that. But we're less focusing tonight on every word, The subcommittee's focused on every word than we are, on a comfort level with the, the changes that I've at least identified from my curation of this that are more substantive. In other words, level 2, level 3, and potentially even level 4, changes, with the rest of it, thought to be in the level 1 category, That's just cleanup of language and corrections and other types of things. So the things that are being highlighted in the presentation tonight really are intended to be both a roadmap of, in general, the work that was done and the review that was done, but really a focus on things that might be considered level 2, or level 3 changes. And we can talk about that as we go. Could you give us one sec to talk about a kind of a technical issue? We're trying to make sure that that what's being said is being properly captured and recorded, both for Brown Act reasons and to have an appropriate, record of this. So, Mr. Chair, if you could indulge me just for a minute's break to talk about what's going right and what's not going right. Thank you. There's the attempts to give me notes here and apprise me of things that I'm so locked in on. Apparently, I'm not paying any attention to at all. We did have issues with the Zoom, communication and recording of the early parts of the meeting. Mr. Chair, the option is to start over, but I think we can recreate, based on our lived experience, what happened in the early parts of that meeting. That's, I'm comfortable proceeding that way for both for Brown Act and for other purposes, if you are.
Well, that sounds great, especially because right now we're getting to the meat and potatoes.
Yes, this is really the really heart of it anyway. So if things weren't working now, then we would need to recess and sort that out before we proceeded. So appreciate that. So with that kind of elaborate introduction to things, diving into the Group 2 report out. Members of Group 2 are, of course, Mr. Kelly, Mr. Beckman, Mr. Crutchlow, Ms. Roberts, and Ms. Peters, all here, and welcome, of course, to supplement anything that I say on these particular issues. And Mr. Chair, I think it might make sense to have questions asked for people who have questions about each item, because it might be hard to save all the questions to the end as we move through these items. But for public input purposes, I would recommend that we wait till the end of the presentation for any kind of public comment or questions there might be about the Group 2's work. So first, yeah, for the levels, level 1, 2, 3, 4. Don't letter them now after I've invested in numbers. If you really want to throw me, then start lettering the levels. Yeah, and for purposes of your microphone, if you notice, you've got to push on the the button on the top for it to turn green in order for you to be heard. Mr. Beckman, I appreciate that. My intent was to actually have that marked, on the presentation. Even now, I just wasn't able to get there, and so I think level 1 and 2 probably doesn't need to be, marked, now, but if anyone identifies an issue, and I'll try to highlight that as well based on discussions with the group, a level 3 and certainly a level 4, issue as part of the discussions, I think that's worth highlighting and discussing with the group. 1 and 2, we might allow to be curated and ultimately, presented and resolved with this group's final recommendation. But that would be my suggestion as we, if people want to chime in and identify levels 3 and 4, it would be a good time to do that. So the first issue to present, and again, there's a lot of wording, right, and more minor issues, than this, but for the larger group's consumption questions and direction. First issue is voter approval for disposal or change of use of certain city parkland. As you'll all remember, there's a provision that was approved by the voters, I'm forgetting now, 2016 or 2018, and embedded in the charter as section 714.1 that essentially said that if the city was going to dispose of, really in any way, for a period of time, 180 days or longer, or change the use for 180 days or longer of any parkland in the city. And there was a definition of that, with reference to a document where the city inventories, its parkland. That in fact, such thing would be subject to a vote of the electorate and could only be approved with a 2/3 vote of the electorate. That's what that measure said. Strictly interpreted, that could prevent some ancillary uses that staff, Parks and Rec, and the Planning Commission has identified as not necessarily adverse, to park, uses, and really ought not to require, a vote of the people. And so input that we actually received as much from Planning Commission and Parks and Rec from staff, on this particular section was suggesting that there be a provision added to allow what have been referred to as secondary uses that do not materially impact underlying park uses if they're approved by a 2/3 vote of the council, right, which you'll remember means 5 votes, and if any revenues generated from such uses are in fact kept and reserved and only used for parks and recreation purposes. And so we got that general feedback from both Planning Commission and Parks and Rec. I drafted some language, to respond, to that feedback. There's a few examples of that, the one of the type of use they'd have in mind, but the one you'll remember that we've identified before is use for telecommunications facilities. Parks are frequently, located in areas that if in fact there's some telecommunications facilities installed there, either on rooftops of the facilities or on the boundaries of those facilities. In fact, that would be useful, for the connectivity, within the city, and could also generate some revenue, that might be used again to maintain either that park or other parks. Other uses were envisioned and talked about at Parks and Rec as well. In addition to that I'm not recalling offhand, but that is the thought. And so that language is included, and the group 2 was generally supportive, of having something like that in there. On the one hand, on the other hand, it is also recognized that this is a voter-approved measure. That the parks in Santa Clara are near and dear to everybody's, heart and want to be preserved. And so this language could be considered depending upon how you look at it, and it would ultimately be good to get, even council's take on this, a level 3, change. Is it the kind of thing that you want to include right in the comprehensive, proposal, or is it the kind of thing that you should pull out, right, and evaluate whether or not it's even worth it, right, to have it be its own measure, because separate measures are expensive. They could cost as much as, and I'm getting final numbers from the city clerk on this, it could be as much as $200,000, right, for a citywide, measure. And is this change, worth it if people aren't comfortable including it in the overall, recommendation? And so that was one of the things that was talked about. If any of the group wants to add their blush or perspective on that, and then maybe folks who aren't members of the group, can ask, questions about it.
Real quick, Glenn. It's on. With respect to the languages, and I'm mindful that you said earlier you don't want to get into the individual language.
Oh, well, we can, if that's what, if you want to talk about that. Yeah.
Don't. I just, for purposes of the rest of the presentations, for things like secondary uses, in quotes, material impact any but not all, is your expectation that when the final language is presented, those will be defined terms? That's not the question I'm going to ask. I was just hoping that as you go through what looks to be like a term of art, whether or not you intend, or the committee likely intends to define it or not. Inclusion in foundational terms.
And we talked about that. In this case, I think the conclusion was it would be hard to define that, and it would require a lot of detail, even to think about that. But I think the thinking was, and how I thought about constructing the language, was that the city council would need to make that determination, right? And if they wanted to adopt policies around that, they could adopt policies around that.
Sorry, I'm not also reading that, and I can't tell what's added. Thank you, Glenn.
And I just had a question, and I forgot if we discussed this.
I
Can you
might
hear
want
me?
to suggest people to be like a rock and roll singer and get your mouth right up to the mic, because I don't think that it'll pick you up better if you put your,
Okay, now can you hear me?
that sounds much better. Yeah.
Okay, I can't, okay. I, I can't recall if we discussed this or not, but why was Eula Stack and the Santa Clara Youth Park, Youth Soccer Park called out specifically?
I don't know. I think, but I have a thought about that. Those were considered so cherished that they wanted to be called out by name. Yeah, those were I think those might have been the assets that the folks who initiated that were most interested in. But they are also ones, it's a little redundant, that were on that list, right? That was also referred to in the language. If anybody else was there at the time or involved in that initiative, maybe you could add some additional information. I'm sorry, that's not picking up very well.
Sorry, I believe it was, they were talking about making a parking lot for that, for the 49ers a few years ago.
Oh, okay. So
Yep.
U Sports Park definitely, I think, was, yeah, as of course, a controversial asset, right, that had been proposed for some alternative use. Eula Stack, I'm not sure. I don't think the 49ers were at that. I think that was probably because it was such a beloved asset and no one wanted, the idea of housing on it, right, or something else in order to compromise one of the few, right, semi-natural, parklands that were in the area. I know members of the council will remember, and be able to, appreciate that. And again, maybe will be resistant to, making modifications, to this at all.
I'm not sure how much. Can you guys hear me? Okay.
Yes.
Our city voted pretty strong on Measure J going back. It was a pretty strong vote to save our parks. And I think the city spoke pretty clearly on that. So anything that we do to possibly amend those uses, I'm for, but we need to understand that the residents have already spoken and they don't want to lose a park. And, I mean, heck, I was one of 4 people who sued the NFL. And of course, we lost, 14 attorneys to 1. There's not a good chance. But I want to make sure we keep the parks near the top. And I am open to hearing any proposal that could possibly align with our current uses. But I don't really think we need to go to a vote again because the residents have spoken pretty strongly about that already.
Yep, definitely some sensitivity there. So again, as you guys have seen, we're both trying to, as we go through this, be politically, sensitive and be respectful on the one hand, and on the other hand, don't completely shy away from things if there's potentially, a modification that would be reasonable and might be well received.
Okay. Glenn, do you want me to chime in on a couple of these things? Just
By all means, member, group 2
So-
member.
granted, we only had a partial group. Regarding the parks, we didn't want to do anything with parks, and we agreed that we should keep it to a 2/3 vote. That way, any changes with any park would be required to be put in front of the voters, and we could discuss the merits. And then obviously, if for some reason we have a better location to relocate a park, whatever it is, the voters get to choose, and it's still going to require a 2/3 vote. Do you want me to go on to the other topics?
No, I think we should take them up, one at a time. And yes, to be clear, this proposal does not change the core, of this at all. No one's suggesting any, primary disposition or change of use, of a park should not be presented to the voters and require a 2/3 vote. It really is just these minor secondary uses that wouldn't have an impact on underlying, park uses. That's under consideration. And again, doesn't need to be the recommendation of the CRC for whatever reason the full, CRC believes is appropriate.
Yeah, the language that you put in, I thought very well reflected it. I mean, you say that are secondary to all and will not result in any material adverse impact on any underlying parks and recreational uses. So it's clear the original primary intent of the property being a park will not be impacted. If it is, we don't go forward.
That's right. Yep, again, with the supermajority vote of the city council required, and the requirement that any revenues be used for park uses. Again, that doesn't mean it's a great idea or that, that this group needs to support it, but there was thought put into, making sure it was just a clarification, really more than anything, kind of a clarification with some protections around, any city council action that wouldn't go to a vote.
So just real quick, following up on Bert's point as well, I think it's because we use terms like materially adverse without defining them that's going to create the political sensitivity. Who, if the city council sits down and says, no, it's not materially adverse, and that's a 5-2 vote, that's it, right? There's no review period built into it. So I feel like it's a level 3.
And, if the material concept bothers either this group or the, or the council, in theory, you could just say any adverse use, right? Right. So there's concepts and there's wording changes, right? We're testing both with this group because ultimately CRC is going to, decide each element of this. So, Mr. Chair, to go on, if I might, qualified requirements for the elected chief of police or qualification requirements for elected chief of police. This came in kind of late because we haven't had a chance to, I didn't have a chance to talk about it, with the chief, and did have some informal exchanges with our existing chief, as well, about that, for his input. We're starting off with a couple hot button ones, right? Parks and the chief of police. But the thought here was that, the existing language for the qualifications of the chief of police, first of all, was in the wrong place, right? It was in the senior officials, section, and it needed to be moved into the elected officials section. And so it's here now in new section 201.2. But if you remember, the existing language was what the elected police, the chief of police did was to keep the peace. Oh, I'm sorry, I'm on a completely different one. Let's not take both of those, third rails, up tonight. But the existing qualifications of the chief of police was the minimum qualifications for a sheriff, within the state, and those qualifications are in the government code, and there's a range of things based upon both years of experience and/or their education. But the bottom line was, with a certain number of years of experience and a high school education, that would be enough of qualification to be our chief of police. And I think a lot of people think or thought, including members of Group 2, that really wasn't, in alignment, with what the expectation would be for what the chief of police would be, the experience that the chief of police would have. And based on conversations with those who know this kind of thing, the belief is that going back at least 30 years with our various elected, chiefs of police, every one of them has at least been a lieutenant with a couple years of experience. Not every one of them actually got the certificate, right? That is, talked about, in the proposed language here. It refers to a post-management certificate, which aligns with being a lieutenant with 2 years experience. Not everybody necessarily had the certificate, and there's some lag, I understand, in the processing of that certificate. But really, everyone, including Chief Nicolai, had this qualification when they were elected to that position, and over the last 30 years. So again, hot button issue potentially, but a belief from that group that that this was a reasonable, upgrade of what the expectation would be for the chief of police, and might even take pressure off, people saying, oh, we should have an appointed chief, right? Because the chief of police doesn't even need to be, qualified at all. So no one's messing with the appointed versus elected chief, but there was a discussion about whether or not the qualifications, could reasonably be, increased. And so that's the thought there. Any number of the members could add additional thoughts to that. I'll be quiet.
I'd like to say of the two items that I just talked, well, now the chief and then the parkland, both were heavily voted on by the residents. And I'm not sure which one actually got a higher percentage of successful votes, was it chief or parkland? But I think our city, again, speaks strongly. And the fact that we're the only city with an elected chief of police is kind of cool. And I think when something's perfect, you don't need to fix it. So, Mr. Nikolai, do you have any input on this, or am I being out of step asking you?
No, not at all. And I've talked to Glenn and I've talked to the current chief about this, and we both agree that it's not necessarily a bad thing to have the management certificate listed there. It would not be that huge of a change to the process, and it would give, again, more gravitas to the position when you had that management requirement. What I discussed with Glenn, and again, this is a group 3 topic that's not being brought here today, is if we're going to do this on this end, then we also need to update on the other end the chief's roles and responsibilities to make sure they're commensurate with being a department head. And I know we've started that process already, and it seems to me that these two things could work hand in hand. So if you make it a more structured position with needing a management certificate, well, then your department head status should be clearer. So I think they go hand in hand.
Our conversation in the committee was quite lengthy on it, and no one complains about someone actually having management experience of officers. What our biggest concern when we added this requirement was that it reduces the pool of potential candidates that could be there, since it's a requirement that they also be living in the city. But we believe that the idea that someone could be elected with no management experience of officers, we would rather risk a small pool than having someone with no experience being in that position.
I have some concerns about it. I believe it's a good move, but my concern again is a small pool of applicants. And should there be no applicants with the required requirements, what do we do? Do we appoint a chief of police? Do we have, it's not even clear. I'm very concerned about it, actually.
Okay, so
How many people are actually able to run for this position?
so
So
that's
how is
one
it
thing
for-
that we discussed in the group, which I'd like to address with
If-
former
let me-
police.
Let me finish. So there's the problem of the size of the pool, but at the same time, if you increase the scope of the position, then we could be subject to some future chief of police who is not capable, even with that certificate. We may have a choice between 0 or 1 or 0 or 0. And I feel that we have to be very careful with expanding the scope of the chief of police, while at the same time reducing the pool. No, that's all I had to say.
Okay, so we did take that up, and there was discussion about requiring the chief of police to be a resident of Santa Clara at the time he takes his oath of office, which means a lot of the people that would be in the potential pool may not be living here, but they're working here. They're on the force. And when we thought, should we allow these individuals that are officers to have the option to run for chief of police as long as they take up residency before they take their oath of office. So that's something we left for the group to decide. And also we thought, if we thought it was a hot button issue, that it could be a one-off. In other words, it could be separate from the charter. But if Pat could chime in on it, do you think it would be okay for the existing force to move to the city rather than currently live here and run?
I don't think you can do that with the election law. I think you have to be a registered, you have to be in the city to run for elected position. But it's not that hard. And just this prior election, where Corey won the election, there was a captain who moved into the city with the intent to run for chief, rented the house and moved into the city. They ultimately decided not to run and they opted not to, but it's not that hard if you decide I want to be the chief to move into the city and have the requirement of being a resident. The other thing is, a lot of times we focus on Santa Clara only, but there are dozens of police departments around us with management level personnel. And I'm frankly shocked that a San Jose captain or a deputy chief has not moved into the city and run for office. I'm shocked that hasn't happened yet. But it's just the way that the process is. So I think you have to be a resident of the city to run. I don't think you can run for office if you're not a resident of the city. Correct me if I'm
Actually,
wrong.
not, yeah, I'm not sure you're right, because this issue was looked at and resolved otherwise down in Chula Vista with respect to the elected city attorney. There was not a requirement for residency in the first place. And I believe the research was done to conclude that that was permissible. They ultimately changed the rule and required residency. And I think that definitely would be required for city council people, and mayor, but I think there may be some exception, for that with respect to professional, positions. But if I might, I think if I could summarize this issue is taken up and it was an important issue, but the ultimate conclusion of this group is this is at a minimum a level 3. And if residency was introduced, it's a level 4. There's a lot of very complex, nuanced things to think and talk about, with respect to this. And so while it was a good discussion and I'm happy to have engaged in it, I want to make sure and I think I'm accurately reflecting the group two's conclusion that everyone recognized that at a minimum, this was a level 3. And if you introduced residency level 4, truly lightning rod kind of issue, as sensible as it all sounds, right? To us just talking about, of course, they should be more qualified. And yes, they've all been qualified, for a bunch of years. Can't we do at least this thing? It might just be too hot, to handle. So I think I'm accurately reflecting the sentiment of that group and the sentiment of this entire group when these types of issues have been presented. No one wants the larger, project, to be distracted from, right, or weighed down or undermined, by including an issue as part of the overall recommendation that's in such a sensitive area.
Go to an easy one.
Chair, continuing on, I hope our pace picks up, because those were definitely the two hardest ones, and it will. I think it gets easier. Let's see. This next one, city council challenges to qualifications of elected officials. I like to think this is an easy one. There was language in the charter that said that the city has the ability to judge the qualifications of elected officials. And when I asked the group, what that meant, or what did they think about that, everyone responded back and go, what does that mean? and I couldn't tell them what it meant. And so the thought was to give some meaning to that, that that the city council didn't necessarily judge the qualifications of people, but that individuals for elected offices. But they would have, and there are provisions under state law, either as an individual person or as a council, to challenge somebody's qualifications under state law proceedings. And so rather than just having councils in probably a very political arena just get to vote to decide whether somebody's qualified or not, the concept was to tie that into state law and have that be a process that the council would need to pursue, under state law. So that was the thinking there, and was the recommendation of the group.
Just for clarity, it is actually 302.3.
New section is, the new section?
Yes.
Sorry, that's a wrong. 302.3? Yeah, so there's two parts to this, Member Beckman. One of it is them judging the outcome of elections. The other one is judging the qualifications of elected officials. One of them is in 201.3 and the other one's in a different section. So you might be, like I do, frequently conflating those two. Okay, yeah, very good. I think we'll get to that. I think that's part of this too.
Real quick, Glenn, with respect to the qualifications, can the electorate challenge those qualifications prior or rather during the election? Or if an unqualified person is elected, then is the proper time?
Yeah, there is a process both, during an election to challenge somebody's qualifications and after the election. Yep. If someone didn't have them to begin with or loses them or someone discovers they're not qualified, throughout their entire tenure, either as a candidate running or holding office, there is a state-based legal mechanism for challenging somebody's qualifications. Yep. And, the qualifications that would apply, of course, are the ones that we set forth in our charter, right? So it's not some other, qualification that someone could say, hey, you're not this, you're not that. It's, are you qualified under our charter, right? Any additional thoughts or questions about that? Okay, that went a little quicker. The next one, I think will go quick as well. Mayor's powers and duties. In the current charter, and again, this is one of the reasons for, the desired reorganization. There's a decent list of the mayor's power duties in one section, but then there's other little things that the mayor is empowered to do that are kind of spread throughout, the charter. And so the thought was, let's put all those in one place. And so on this next item, old section 704.3 and others becomes new section 202.1. What these revisions to is it gathers all the various mayor's powers kind of in one place. It doesn't really make substantive changes, to those. It's really just there's a wording change here or there, but not really any meaningful substantive change to that. But one change that made sense to the group and to me, there was kind of an odd provision in, I'm going to get to this section here, 202. There was an odd provision. Oh, I need to go to the underlying strikeout. In the charter that put a caveat on the mayor's ability to make recommendations to the city council on matters of policy and programs which require city council decision. And it went on, that section went on to say, provided that if they recommend any increase in the city budget, they have to find the funding source for that. And if they recommend any reduction in the city budget, they have to recommend specific cuts. Okay, that's not a thing that in this complex, world we're in, that a mayor or a city council person, as a condition to them making any recommendation, could reasonably be asked to do. Of course, that needs to be part of the discussion, right? And of course, ultimately, when the budget's decided, the city manager would present, and the finance director, an analysis of that, and a decision would need to be made. But this appeared to require, as a condition to anyone making a recommendation, that they need to have sorted out kind of what the funding, where the money is going to come from, or, what the cut would be. And so the thought was that that would be hard to enforce anyway, and really isn't, a practical, condition on that. So the only real substantive change to this, provision was to propose to eliminate that somewhat gratuitous, kind of impractical condition on the mayor's ability to make a recommendation, right, as a policy matter. The thought was, as well, and we'll get to this in a minute, that when we created the list of what city council members had the ability to do, that of course, the ability for them to make recommendations, to the council about and to staff about what, policy changes there would be, that would be listed as one of their rights as well. There's nothing unique about the mayor's status, right, that only allows the mayor to make policy recommendations. Any city council person, including the mayor, would have that ability, and they ought to be on the same par for that. So that was the thinking there. Again, no real substantive changes to the mayors, but just getting rid of some kind of gratuitous, anachronistic, why is that there, language that really doesn't, the thinking was, have any practical kind of value or reasonable restriction. Any questions or thoughts, either from the members of Group 2 or the rest of the CRC on that provision? The next section is City Council powers and duties. Old Section 706, which really didn't have much to it, and new Section 202.2, which really proposes to, just like the mayor had detailed, powers and duties, listed, that city council, the city council and city council members ought to have some language in the charter that describes what their duties are as a group and describes what their duties are as individuals. And it really was intended to put context around, what a city council's powers are. And the charter right now just says all the city's powers are vested, in the city council. And instead this says, which includes a list of the things that they would do. And if you look at its new Section 202.2, there's a, in general, section, and it talks about what these things are. And none of it's particularly controversial, right? And in a lot of it cross-references the various powers and things that they do throughout the charter. For example, certify elections, declare elected official vacancies, and appoint elected officials to vacant positions. Appoint the city manager, the city attorney, and the city auditor, again, with all cross-references to where that happens. Appoint members of city boards and commissions. Adopt ordinances, resolutions, and policies. Take actions on fiscal matters. The ability to conduct investigations and to subpoena witnesses in certain circumstances. And so it really is intended to communicate really to the public, right? What does a city council do, right? What things are they expected to do? And frankly, to, people who might be candidates, for that office. One specific thing it does, because there was a general provision that talked about a very broad power of the city council to investigate people or subpoena witnesses, that there was some concern, at least from my office, that would be overinterpreted as something that they can do under any circumstance. This language, as revised, puts that in the context of the overall powers of the city council and in the context of where this power would apply, which is they could investigate and subpoena witnesses in personnel matters involving city council appointees. In other words, if they had an issue with the city attorney, right, and thought that my conduct, was inappropriate, they would have, because they appoint me, they would have the ability to investigate, me and subpoena witnesses, as part of their evaluation of my performance or in connection with discipline matters or otherwise. And they would be able to do that with the city manager as well. Since they don't appoint individual employees that the city manager appoints, they would not be able to investigate or subpoena people with respect to people they don't have authority over, right? So it's intended to put it in the right context of what their authority would relate to. And of course, they also make quasi-judicial decisions, both on permits and in other matters, and thereby its very nature, right? They need to be able to investigate, and subpoena witnesses in connection with that. There are broader authorities that city councils have under general laws in the city. For example, if they're going to collect tax debts, right? The city in general, and potentially city council acting, needs to be able to conduct investigations. Really, city staff would do it, but potentially with city council direction, to evaluate whether or not someone is committing, fraud and not paying, transit occupancy taxes, right? And to subpoena witnesses in that context. So to the extent there's a state law, position that allows you to do that, that's also included in there. But it's not the way it was currently drafted, their ability to do that under any old, circumstance. And so the thought was, hey, where things aren't clear, clarify them. And so the language in this section clarifies that. My office thought in a way that gave the appropriate broad application to what that power would be. So that's one of the provisions of that otherwise long kind of new list of city council powers. The other thing that I think this group too thought was especially important was to talk about what individual council members' powers were, with some emphasis on their obligation to consider or just both solicit and give consideration to public input, to comply with ethics rules, and to be professional and courteous, to one another. I think a number of you have expressed to me and to each other that one of the things that motivated you to get involved, with this project was observed, behavior and conduct, at the city council level that gave you some concern, and the desire to, aside from all the rules that we have already, give some elevated grounding within the charter itself, right, about what the expectations were for the conduct of, elected officials in office. And so at your request, I put together some of that, language that's now in the list of 202.2 here, that kind of gets at ethics, and behavior, issues in a way that didn't appear in the charter before. I'll read a couple of them. Item 202.2 B4, conduct themselves in accordance with all applicable laws, including the provisions of this charter, the city code, and all adopted city policies. Number 5, in the conduct of city business, place the interests of the city above their own personal interests. And item number 6, in all interactions with each other, city staff, and the public, conduct themselves in a professional and courteous manner. Again, there was a thought that to the extent there was a desire to emphasize that behavior and that conduct as something that is valued, that those concepts should be included. If we're in any list of what the city council members' powers and duties were. And there's other more routine ones here that are listed, of course: attend and participate in meetings, give due consideration to input from residents and businesses within the city, city staff, consultants, et cetera, and other stakeholders. Again, the kind of stuff that, again, would give, we think, the public an understanding of what the expectation is for council members and any candidate running, for office of what the expectation was. And so that was the thought of Group 2. Hopefully I did it justice. Would ask if the Group 2 members had any either supplement or contrary thoughts to how I described that item.
Hey, Glenn, Glenn, hate to poke humor at my city, but Can we also put on a list, no book reviews by people stepping in as being the person running our city? That was an embarrassment that I really can't get out of my mind, having someone attack a person who's helped our city publicly and make humor of it.
Yeah, I mean, and that's pretty specific, right? I think that anyone can probably give a variety of different examples of things they've observed, that would be viewed as not appropriate. I think the professional and courteous, language was intended to get at things, like that. And of course, the city's adopted, pretty detailed policies that get at that in a variety of different ways too. So I think that's captured.
I'm sure I just had to bring it up because it's been on my mind. I can't unsee what I've seen on that episode with Kirk, and I was really embarrassed for our city over those few minutes.
Yeah, and one of the things I know different people have different views, right, about different people's behavior. One of the things I've been trying to do with this is obviously everyone's got their observed experience and their opinions about this, but to try to depersonalize it, right? It's not about any one person's, conduct or what any one person, said. It's really about what is the expectation, right, of anyone's, behavior in that circumstance, with people being able to potentially give examples, of anyone's, individual behavior. But appreciate that. Again, everyone's got their own observed experiences with that. The idea is to capture a good principle, and ground it in the charter so that it's a broad application.
And following up on what Bert said and yourself, these are what we expect. They are not qualifications. So the no reelection remains the remedy. We're not introducing a new one to a rude city council person.
That is right. I think there would be the idea that would be actionable, right? Because it's listed in the charter is probably too much, to ask. They're just intended to be kind of guidelines and expectations on behavior.
I was also going to mention one of the final ones is a self-policing option.
Thank you.
Or not an option, a requirement now that, if at any point in time a council member finds himself no longer qualified, they need to bring it to the council rather than the council having to discover it.
Yeah, that's a great example. Yeah, and that came from the group in the context of discussing vacancies, which we'll discuss, in a little bit. And, how do you know about these things? How do you find out these things? And yes, I think that's a good one. It's item 7, report to the city council the occurrence of any event listed in section blank. It hadn't had the full cross-reference yet of the charter, which may result in their disqualification for office by no later than 15 days after the date of such occurrence, right? So if you, move out of the city, if you die, you need to report to the council that one of those things has happened. Yeah, we'll talk, but again, or a conviction, right, of the kind of crime that we'll talk about when we get to the vacancies and stuff. Yeah, appreciate you mentioning that. I thought that was a good addition to tie it into the vacancies. And again, the expectation that you're supposed to operate at a high level, right? And that if something happens that no longer makes you qualification for office, it's your first duty and obligation to apprise people of that. The last one here in city, I'm sorry.
Regarding, you enumerate the powers of the mayor, and then you go on to list the powers of the council members. Many of the items under the council members are about conduct. Do these itemized lists also refer to the mayor?
Yeah, that's a great point.
Any of the limitations on the council members apply to the mayor?
Yeah, that's I appreciate that point. There's a number of places in the charter that talks about.
Glenn, did we not talk about that? About the mayor is one of the council
Right,
members.
that's
so
what I was
by
just gonna
virtue
say.
of-
But not in this context, it doesn't, right? In other places, especially with respect to elections, and qualifications, it talks about that. That's a really good point.
I mean, if you simply just said individual council members and mayor.
Yeah, including the mayor. I think that's a very good point. It was not intended not to apply. And so I think that is a good suggestion if the rest of the group thinks so.
Can I bring up something? What if there's a requirement they have to be a resident of the city to run for office, and they do live in the city, but they choose to live outside of the city while still paying rent in the city. So they could live in Gilroy maybe and commute in, but they're paying rent. Is there a time that they're allowed to be basically not a resident of the city that they're elected to be in?
Yeah, I don't think that's for that's this group's.
Oh, no, that's just, I'm just bringing it up because what if somebody did get elected, but then they chose to live in Gilroy?
So I think we'll talk about that when group one comes back, right? I don't think that's in this one. The concept of how residency is defined and who oversees residency is a group one area. Briefly, though, just to answer your question and put it in context.
Glenn, you have enough on the plate. I'm just bringing it up, just.
Yeah,
conversation.
it's defined by state law.
Okay.
And administered in the election process, by the registrar of voters, and the city clerk. What residency means isn't as clear as you think it might, it might be. And we can dive into that a little bit deeper when group one comes back and that issue is addressed head on.
Fantastic. Thank you.
Yeah. But that would be if you, for example, moved, right? First of all, you need to qualify in the first place, but then if you moved, this would be an example of something that would result in your office being vacant and you being disqualified for office. And if you moved, you'd have to report that, out. If in fact you moved in a way that disqualified you for residency. There's a last one here, bullet on the slide 15, councilmanic interference, that fancy term that in effect restricts the individual council people from taking on administrative, functions, things that they're not authorized to do, things that the city manager, does in his administration of the city. The language around that is included here, and it's still prohibited with some additional language that if in fact the city council attempts to do something as a group by ordinance or resolution, that any such action would be void. For example, if the city council tried to appoint the director of finance, they are not authorized to do that. They only appoint the city manager, the city attorney, and the city auditor. And if they attempted by resolution to appoint the director of finance, that action would be void. And so there's language, in there that makes that clear by operation of law. But there is a section in there that was pulled out and will be taken up, I think, better by group one when we get to that regarding violations of the charter. There is a provision in the existing councilmanic interference, section existing and now renumbered 202.2 that talks about any member who violates this or who votes for a resolution or ordinance is guilty of a misdemeanor and it will be removed. So there are absolutely instances where a council person violation of the provisions of the charter, might result in, their removal. We're taking all of that and putting it in a general section as opposed to having it be, if you violate this section, you could be removed, or if you violate that section. The idea is to take that up, as a general matter, as opposed to have it embedded in individual things. And so when the group one reports out and that comes back, you'll see how that's handled. But it's not gone. It's just now being moved and put into a broader context. Okay. It does get a little easier here. There's still a lot to talk about with group two. Welcoming member Crutchlow to the group at 7:28 after finishing his planning commission meeting. Thank you, sir. Yeah, not nearly as fast as anyone thought, right? Uh, So the next section on now page 16 of the PowerPoint. You may not have gotten. Dude, do you have a PowerPoint? No, those are the attached ones. Now on page 16 of the PowerPoint. Term limits. Old section 600 and now new sections 203.2 A and B has added language that clarifies the term limits are lifetime term limits. It really, it doesn't change it, right? That is what it says, but it says it much more clearly, now than it did before. With notably, and again, I think even more clearly, service in one office, not counting as service in another office. In other words, if you were a city council person, for 2 terms, you could still run for chief of police if you had a management certificate or whatever, however we end up, on that. Or a council person, right? Or, a council person had served 2-year terms as a council person, or the mayor, vice versa. They could then run for mayor or council, vice versa. So that's the existing standard for that, but made that much more clear. And then also, notably, and not proposed for any change, because that would be a pretty significant, hot button change. There are no term limits in the charter on the elected chief of police or the elected city clerk. I am not proposing any such thing. Would be a very meaningful change. In theory, that could be a level 4 thing if someone thinks, that term limits should apply. But for me, and again, clarifying what the charter says, doesn't say it anywhere now, it just doesn't impose it. It's now going to say, hey, there's no term limits, for these, two positions, to make it crystal clear. Any questions or comments from the group about those changes? I think they really are just clarifying in that case with some better wording, and not as fussy of wording. The next section, compensation. Old section 906, now new sections 201.2 and 604.5. You'll all recall, particularly Group 2 members, that the salary for the salary and benefits for elected officials is determined by a salary setting commission. And all of that is contained in an elections section. It's now proposed that the details of the salary setting commission now be moved to the boards and commissions section. Salary setting commission is clearly a charter created board and commission, so all of its terms and conditions have now been moved logically to that. But there's some, we're going to jump around here a little bit to get to that, but the one of the substantive aspects of that was talked about, that's just vague in the charter, but is being interpreted and implemented by the salary setting commission in a way that ought to be not made vague, in the charter, is what kind of benefits is included in the total compensation of these elected officials. The language is, like I said, is currently vague. It's now very clear that salary and benefits is together constitutes total compensation for elected officials. And per the current practice, and the understanding of the Salary Setting Commission, even though they have not decided to provide any health benefits at this time to those part-time positions, but per current practice, there is the possibility of paying the mayor, council, or the city clerk health benefits, and they would qualify as well if they stayed in the position long enough for retire benefits under CalPERS. Our CalPERS plan potentially provides retirement benefits to, to be people in this position. Not a huge benefit, right? Because they don't get paid that much, but based upon what they're paid, and the number of years of experience, if they stay in that position for 5 years or more, they could also vest, in CalPERS. So these revisions now make it very clear that total compensation includes this, a schedule for actual salary that can be paid to them that can only increase by 10% every 2 years, 10% every 2 years, because they only meet every 2 years. And so in effect, capped at 5%, a year on any increase to their salary. And they may, even though they haven't yet, evaluate whether or not they could get health benefits. The health benefit is limited to standard health benefits, right? Medical, dental, and vision. But it also makes very clear that because they're part-time positions, they cannot, if in fact they ever get paid that health benefit, they cannot convert that health benefit to cash, right? This is intended not to be additional money to them. It's intended to be a health benefit if it's ultimately determined that they would get that. And so if you look at all the language now in section 604.5, I think that's the right reference. It's Article 6, which is all the various boards and commissions. You will see that there is now a salary setting commission at the very end, and it takes some of the language that was in section 906, but puts it in the format of all the other boards and commissions. The first section is the composition and appointment, right, which is already determined. It doesn't change that. The next one just describes what their powers are, and it makes clear now that the health benefit is one that can be provided, but that it can't be convertible to cash. But it understands that the benefits, again, for the part-time positions are limited to that. It does not limit those benefits to the chief of police, who is the head of the department, right, at a minimum. And so in effect, the chief of police is entitled to, whatever, benefits might be, the salary setting commission would determine are commensurate, with the chief of police position. So these limits are only intended to apply and have been interpreted to apply only with respect to the part-time positions. It does not purport to limit anything that's currently available to the salary setting commission in order for their compensation paid to the chief of police. So for me, it's really more clarification of how things work already. The charter language was much vaguer, that it should have been in that regard. And so that was the intent, and I think it's accomplished pretty well. Any questions or issues with compensation?
Just a note that the old section 906 and new section 201.2, I think are incorrect. I think that's related to the chief of police. The old section should be 702.
I'm sorry, for compensation?
Compensation.
Old section 702. Thank you. The new section references are right, though.
I think 201.2 is still wrong. I don't think that's,
Oh, for God's sakes.
thanks.
Thank you.
To ask another question, I'm sorry, regarding this commission. If the commission can only raise salaries by 5% per year, why bother with a commission? And I mean, it's really, I believe these salaries for most of these positions are quite low. I don't believe the 5% a year is going to induce more people to run for city council. But it looks like you are creating possibly, highly paid salary positions, perhaps to the voter. So I'm not sure if it's worth including here, just because the number is so low.
Appreciate that. Good point,
Maybe something more like 10%?
but
I'm not suggesting we should make it higher. I'm just saying that
yeah,
if they're limited to 5% per year, and I think the city council members are only making a few $1,000s a year,
that's right.
why create a commission to simply give them a few dollars more every year?
Speak to that.
Yeah, very, very good. Thank
Um,
you.
So there already is a commission that exists now, so we're not creating a new commission, but we're trying to clarify some of the language. The previous language, it seemed to use the terms compensation and salary kind of interchangeable, and that was a bit confusing. So what we've tried to do here is to establish clearly what the commission can do. The limits are the same in terms of how much they can increase salary per year, but we've clarified that if they so choose, they could add health benefits. So that is something to give flexibility going forward. In addition, the limitations on some of these benefits are for part-time employees, which all of our, the city council and the mayor are. We're not going to decide if those are full-time, but it just clarifies that.
I think it does say here, the mayor, the chief of police, city clerk, and then you say under that, under number 2, that those salaries cannot increase by more than 10% per year. I believe I heard Glenn say that the chief of police compensation was set differently.
The chief of police benefits are not included in the benefit cap.
This 10% cap would also apply to chief of police.
I think it does. Yeah. Yep. Speaks from experience. Yeah. So, I mean, the other thing, of course, about the anything that would change salaries, for elected officials is certainly nothing that they would include in an overall, recommendation. It would look like they were trying to hide a raise for themselves, in that. So I know you weren't suggesting to alter that, but that might be a third rail, or level 4 thing. If there was a suggestion, hey, maybe they should, be paid more or be full-time or anything like that. I think that is a clear level 4 item in the context of this project. Any other questions or comments from the group about compensation? Thank you, Member Peters. You described that much better than I did on the first presentation. Okay, moving on then, if I might, Mr. Chair. The next item here is vacancies. One thing that, and this is something I noticed, there are some pretty detailed provisions that were tweaked a bit regarding how the council went about filling a vacancy, but it didn't define anywhere what a vacancy was. That I thought was a pretty significant material omission, from the charter. A lot of charters have that pretty clearly specified. There's a pretty clear, with some variations and one of which we'll talk about, for, what that list includes. And so I presented to this committee, and this committee reviewed and suggested some modifications and ended up with, what's before you today, adding some language to the vacancies section. It was old section 703, and now it's new section 205. Hopefully I got those references right. And you can see here 205.1 says what constitutes a vacancy, and it lists them. No longer meets the qualifications necessary to hold the position, right? There's those qualifications that are listed. You have to meet those throughout while you hold your office. This next one we spent some time on is convicted of either a felony or any misdemeanor involving either moral turpitude, never been able to say that, or misconduct in office under applicable law. We talked a lot about what moral turpitude might mean or not mean. We just decided to refer to applicable law. There are some examples in applicable law about the kinds of thing that constitute moral turpitude, and a lot of it's just kind of evil intent or dishonesty, in the particular, crime involved. But clearly, if it was a misdemeanor that was this elevated kind, right, defined under state law to be moral turpitude or misconduct in office, the idea, if you're convicted of that, that would be enough, right, to in effect have you forfeit your office. There's a lot of discussion around that, but that's where the group ended up. If you're recalled from office, of course, by vote of the people, you lose, your office is vacant. If you resign, if you're sworn into another position, right, that is incompatible with this one, as soon as you're sworn into that second position, you also forfeit this position. So that's listed. If you're removed from office by some judicial procedure or state law proceeding, it could be any number of things, but of course, that constitutes a vacancy. This is one that existed already here, and it was kind of the only one that existed, is if for a mayor or council member, you're absent without approval of the city council for 5 consecutive convened, regular meetings, thank you, then that would also be a basis for you losing office. If you're judicially determined to be physically or mentally incompetent, or if you become personally disabled so as to be unable to perform your assigned duties as determined by an affirmative vote of at least 5 council members based on competent medical evidence. We did a little bit of tweaking of that to make sure that was fair. Or the last one, of course, if you die, which you must report immediately. So different people could describe, right, in different ways what constitutes a vacancy. The charter should say, right, so that there's no, misunderstanding. And your poor lawyer who's being asked, whether this results in disqualification or someone in office or not, actually has a charter standard, to refer to, which is a pretty conventional one with some fine tuning that I thought was thoughtful, by the group. Any of the members want to talk about that vacancy list? The next section that was here already, but is now made a little bit more clear in terms of the process, is how the city council might go about appointing somebody to fill a vacant seat. And the first step of that we created is they really need to declare, the position vacant. And once they find out that information, they have to do it within a certain period of time. And then from a certain period of time from them declaring the vacancy, they have the opportunity to fill that position by appointment. The current charter had 30 days. The thought was that might not be enough time, particularly with how political those things can get and the need to actually conduct a recruitment process, right, and an interview process and ultimately making a decision. It could take multiple meetings. I've gone through these. They are very challenging and they take multiple meetings. And so the idea that could happen in 30 minutes, and frankly, even in the 45 minutes, that's 45 minutes, 30 days, or even the 45 days that's proposed could be pretty challenging. But the thought was, hey, there should be at least a reasonable amount of time, in order for them to do that. So a fairly modest recommendation to increase that time to fill from declaration from 30 to 45 days. The other part of this that's potentially a discussion point, and group 2 maybe can remind me of where we came out with this. I don't know if we came out definitively on it, but we had fun with the word forthwith. If in fact the council fails to make the appointment within that period of time, what the charter contemplates is holding an election, right, for that position. Okay, you failed to appoint, so you can't just leave the position vacant, right? You've got to hold an election. But when do you hold that election? Well, the charter, under its existing language, says forthwith. I don't know what that means. You might argue that it's at the next, available election. You might say, no, you've got to call a special election because it says forthwith, kind of do it right away. I asked the city clerk what the recent experience has been with that. What she pointed out to me was that the last time that this occurred, they waited for the next general election, right? Is that forthwith? I don't think, forthwith is defined. And so I would suggest that forthwith be defined because I don't know what forthwith really means. You could say at the next special election, you could say at the next general election. It's a balancing of interest, right? Special election potentially happens sooner, but special elections are very expensive. A general election might have you waiting, right? And so the position might be vacant for a long period of time, but more voters will usually come to general elections, right? And it would be a lot cheaper because it would be consolidated with another election. This is a little bit of a sensitive area. I'm not trying to be provocative by suggesting that it be resolved. I just see the word forthwith, and I don't know what that means, and I don't want people fighting about, when they have to call the election in what may be, a highly charged, sensitive political environment where someone's lost their office and now people are deciding, whether to appoint, and if they don't appoint, there needs to be another election. And so interested in, if I'm the group's two recollection of if there was a consensus of where you came out, and obviously ultimately the CRC's input on that for when this comes back to you for final recommendation. You might get close to that. Yeah. And turn it on.
So now I have a hot mic. Great. I think the key was,
There, yeah, even closer. Yep. I'm sorry, because it doesn't, if you get real close, it picks it up, but I'm not sure it picks it
all
up
right.
very well. Yeah,
Can you hear me now?
I can. Yeah,
All
very
right.
well.
I can be really loud without the mic too. So, all right, here we go. So I think the key was, when is the next election? Because number one, we don't run elections. The ROV runs elections. Otherwise, it's very costly for us. So the key is, okay, if we're close enough to an election coming up, let's just use that and live with it. And I think some of the dates we were talking about was like 6 months or things like that. Otherwise, it gets extremely expensive. So forthwith, what I saw as definition, it depends. And the courts then come in and decide. And by the time you go to the courts, now you spent a ton of money. So we were trying to make it somewhat reasonable.
Glenn, during your earlier perusal of the various charter cities in California, did you come across a time period or an average time period after which they appointed or waited?
I did not benchmark this, but we certainly could. Or if I did benchmark it, I'm not remembering what the outcome of that was. Yeah. Courtney might benchmark it right now while we're waiting, if you're asking. And that would be fair again for any of this, right? If the group's, not sure about it. One of the things, if you said, hey, if I only had this additional information, I could be sure about it, that, part of the direction staff would be, hey, when you bring this back, bring back benchmarking, right? On what this item would be. Please don't give us too much to do, but that would be a reasonable one. Yeah, so I would need the city clerk to comment on that. As you know, we don't hold primaries here, right? We only hold, a general election. We only hold the general election, which is November, elections. And so potentially there would be savings in consolidating with a primary election if there was one that was going to be held. Yeah.
I'd like to point out that I found an old pile of mail, ballot for mosquito abatement. So that was an election apparently, and I didn't know about it. So not sure if that qualifies as a.
Or I'm sorry, for what? For mosquito abatement?
Mosquito abatement.
Yeah, I think
spraying.
that was a smaller election within your vector zone.
Yeah, I had no idea.
Yeah. So if you could, we could build in language that suggests that the election be held at the next mosquito abatement election as a fun quirk for our charter. But yes, that could have been aligned with one, but Chair, your question's a good one, right? Is if there would be some value in consolidating with a primary, then that would be both something that the public would be more likely to participate in, right? As opposed to a special, which could be, any number of different, times. And could happen sooner, right, than a November election. That might be worth looking at if we're going to define, right, the next available general election, which could include, a primary, if in fact that's a general election. I could check with the city clerk on that.
I do feel like we discussed this though, and didn't we suggest as soon as practical? Also, that seems familiar.
To the extent practical?
No, as soon as practical.
Oh, as soon as practical.
Yeah.
Yeah. I think we did in a different context. I think in this one, that wouldn't help me much more than forthwith, because what does practical mean? Yeah, no, but no, I get the thinking. We may have talked about that, and I may have said, "Oh, yeah, that's good" at the time. But I don't think, and as I'm thinking about it now, that's as helpful as being a little bit more specific with it.
I'm looking it up, and California has a government code 36512, and it's saying 60 days. And I don't know if this is something that is applicable to charter or for those cities that do not have a charter, but I'll just refer it to you to take a look at. But that would be maybe a suggestion that they have to do it within 60 days, in which case I think that means millions of dollars.
Yeah, I mean, I don't think you could even conduct an election in 60 days. But Courtney is in fact benchmarking as we speak. And maybe by the end of the meeting, we'll have benchmarking on it. But it sounds like there's a desire for a little bit more definition, right, around that. It is a meaningful thing. And again, there's a balancing of interest, right? Speed and getting an elected person in, as soon as possible versus practicality, and the costs of things, because elections are expensive, particularly if it ends up being, if it's a citywide one, right? A council person election, if it's replacing a council seat, isn't actually that, expensive by comparison, but a special district election, still could be.
So save you some time to follow up special agent with my own. It's 60 days to appoint or call a special election. If failure to appoint after 60 days, you have to call the election.
Yeah, so that is a general law city rule for how they set up their appointment process. They're more generous. We only had 30 days. We're now proposing 45. Apparently general law cities allow 60. But then if you don't appoint, you have to call a special election, right? And then the process for calling a special election takes some time. And the city clerk would have to speak to that.
They were saying here also, if the city council calls a special election, the special election shall be held on the next regularly established election date, not less than 114 days. How they figured that out, I don't know. From the call of the special election. A person elected to fill the vacancy holds it for the unexpired term.
The unexpired term. Yeah, we've got language like that for unexpired term. Right. So anything we come up with will be better than forthwith.
Glenn, can I suggest we strike that term from our charter?
The word forthwith was unanimously agreed would be stricken from the charter.
Fantastic.
Forthwith.
Great job.
There's still a couple of thereofs in there though that I'm working on trying to get out, but sometimes thereof is useful. Okay, so I'm perceiving a little bit of consensus to come back with some additional information, some desire to pin that down further, but not necessarily just general election. And so when that comes back, we can do some work on that. City elections generally now, we still have a lot to talk about. Old section 700, new section 300, language added to clarify the relationship between local and state law. This is just some good cleanup language. I'm sorry, I'm bragging on this with the there's not really much to talk about here. The group spent some time looking at that language. I wanted to be very clear, since we our charter city in theory could run our own elections. Really, very few cities run their own elections, right? You coordinate with the registrar of voters, and your registrar of voter kind of runs your election with your local law, kind of requirements, and your candidate, filings being administered by your local city clerk. This didn't have our existing language didn't have how those two offices worked together very clear. It's now crystal clear as a result of this revised language. And we consulted with the city clerks about how that should work. Going on to page 18, summary of recommended changes continued still. The administration and determination of election outcomes. Member Beckman, we talked about that one earlier, right, with respect to determination of qualifications. This one, I think, makes clear what their city council's role is in determination of election outcomes. Previous language said they shall judge election outcomes. They don't judge election outcomes, right? That's all run by the registrar of voters. The registrar of voters counts the votes and determines who wins. What the city council does, as in language that's, or in a process that's pretty well defined by state laws, they certify, the election. And so this now is revised to reflect that the city council will acquit themselves by certifying the election, but will not substitute their own, determination of what the election outcome is, for the city, for the ROV's outcome. It also includes, again, clarification of the relationship between the registrar of voters and the clerk, with the addition of language. The city clerk is the elections official, right? But the city clerk, the elected city clerk, is the elections official officially under the charter. No one's proposing to change that. But this, usually an elected city clerk isn't an elections professional, right? They're not experts in running elections. They could develop that expertise, but that's not a common criteria. So while the city clerk is an elections official, and the one we have now takes that responsibility, very seriously, and works with the city clerk and makes sure, things are being done correctly, he or she, would materially rely on, right, the professional city clerk to assist with the administration of those requirements. And so this sets up that and clarifies how all of that works. It also says that the senior appointed clerk, right, the person who's not elected, in connection with any election and matter that relates to the city clerk being elected, right, who, as you might imagine, might have a conflict if they're administering their own elections, that the appointed city clerk takes responsibility for that in that instance. And so that's now explicitly provided. Any questions about that language or those concepts? City council members elected by districts, old section 700.1, new section 803. Really, this is largely cleanup. This language came from the court order that administered, this district election, so we didn't want to mess with it too much. But it included a provision in there that required the voters of each district to nominate and elect their candidate. The voters don't, collectively nominate anyone. We don't have a primary election that's done by, 20 people who sign a petition. So that language really was confusing and inaccurate. So we deleted the word nominate in that, and that's really the most substantive change, in that section. Redistricting is something that's mentioned, but very lightly in this charter. And so when it comes time to redistrict, there really isn't any guidance about how that should work. We're actually coming up on a time to redistrict. Redistricting is mandated under federal and state law, I believe, every 10 years once the decennial, census, information is made available. And there's a time period by which you have to evaluate, based on, new census information of how many people and of a variety of different qualities live, in different parts of your city, and you need to go through a redistricting process. Our charter didn't speak to that at all. Most charters do, some in great detail. And the thought here was to not go too far with this because it could be a very, controversial thing, but at least provide for some process and a requirement that a city council would adopt an ordinance and policies in order to implement what is soon to be a material requirement. I'm Member Chair, being interrupted by one of your colleagues. Yeah, of course.
I think the city council members elected by district is 303, not 803.
Oh, thank you.
Yep. I couldn't find it under 803.
Section 303. There was some, I tried to be as good as possible with this, but both typo possibilities and me cutting and pasting from other, sections. So thank you for catching that. Good. At least I wasn't speaking incorrectly about redistricting. That's what I was worried that I was describing it wrong, but thank you for catching that. So the consensus of the group after a fair amount of discussion around this was, hey, it ought to go, something ought to be included in the charter that speaks to this, but not with any great specificity because how a redistricting commission is chosen. Or I'm sorry, I jumped ahead. The thought was that there should be a redistricting process described and that consistent with both best practices and some independence of decision-making, that a redistricting process should also include the requirement that a redistricting commission be created. It is not a requirement of state law or federal law that you have a redistricting commission. The city council could itself implement and make the ultimate decision on how district boundaries, should be drawn. But most jurisdictions, including the one that I came from, as a very conscious matter of introducing an independent process, to this, so that the elected officials themselves, right, aren't deciding what the redistricting, should be, appoint a redistricting commission. Frequently in a very complicated, manner in order to make sure that they truly are independent, and not political. And then they go about the analysis required legally in order to make a recommendation. And depending upon the local jurisdiction's, preference, the redistricting commission either can make that determination themselves with no input or oversight, from the city council. They could make a recommendation to the city council and the city council could then make that determination, or any number of things in between, right? That have the process, being a recommendation on a potential referral back. And so the thought from the group was, we need a redistricting process. A redistricting commission is a good idea, but we will ultimately leave to the city council to make by policy, right, the details about how this redistricting commission operates. And I'll turn it back over to group 2 folks to make sure I describe the thought process correctly on that. I'm seeing nods, Mr. Chair, so it looks like I described it fairly correctly. Yep.
So real quick, Glenn, as we've seen at the state and federal level, the time and process for redistricting is political expediency. I wonder if that's possible under the charter as it stands, and if that's something we could avoid if we were to amend the charter to include this commission.
And I'm sorry, the condition is other than political expediency. What
I just meant there actually would be, it is every 10 years, there will be a commission and the commission will make that recommendation to the city council.
Yeah, this does provide that that it has to happen every 10 years. It's a mandatory process for, every 10 years. There are abilities to do it. I get what you're saying. So you're saying they can't just do it, in between. Yeah, I hear that. I know there are abilities to do it Other times when, for example, the boundaries of the city, might be adjusted, right? And so that might alter, populations. But yeah, I don't think we talked about that at the group level to limit it from happening other than as necessary based on the mandatory, redistricting or an actual change of boundaries. Not an unreasonable thought. Yeah. Which I'm not surprised at coming from you, Joe. I didn't mean to suggest that, that I was surprised that it was not an unreasonable thought.
Be more unreasonable when it's our material. don't
Yeah,
worry
what,
about it.
so that is something, if this group wants to refer back, could come back as an option when the full language comes back to you. Finishing up, finally, I know this is grueling with the group two's recommendations, city council meetings and actions. Hopefully I've got my section references here correct. Old sections listed, new section 400. There, it was a minor change proposed here to add a flexibility for the requirement to hold 2 meetings a month. To instead, to at least allow 1 month to have only 1 meeting. In the event that during the summer recess or around the holidays, only 1 meeting could be scheduled, to at least allow that to happen 1 month. This council has way more than 24 meetings a year. The last few years have averaged 40+ meetings a year. So I don't think people are being shortchanged, with the number of meetings that are called for. And then there's also a provision that clarifies that any action taken at a regular meeting can also be taken at a special meeting, except as required by the charter. There is a provision that Group 1 will present that talks about whether or not ordinances can be adopted at a special meeting. I'll wait for that to be reported out when Group 1 gets a chance to present. Procedures and requirements for action. The old sections 710, 712, and 713, and new sections 402.1, 2, and 3 provides a variety of different language changes, including clarifying the quorum requirements per existing rules and best practices, that a quorum is a majority of the actual membership of the, shoot, I'm forgetting the language. The clarification is that, that for so long as the council is comprised of 7 council members, that 4 city council members, and again, that includes the mayor, shall constitute a quorum, and that the vacancy of 1 or more city council seats shall not alter the quorum requirement. In other words, if there's only 6, or if there's only 5 council people because there's 2 vacancies, quorum does not become 3. You still need 4, members to constitute the quorum. So that's a clarification and a standard quorum requirement. The procedures also clarify the senior appointed clerk's responsibilities to assist at meetings and keep the records of proceedings. That is not an elected city clerk function. This elected city clerk frequently comes to meeting and is supportive of and helpful at those meetings, but it's not one of his assigned duties. It's assigned to the senior appointed clerk, and this reflects that. And then there's clarity added to the standard practice that 4 affirmative votes are required by the council to take any action unless a higher number is required. Sometimes under law and under the charter, 5 is required, but now that's clarified. The last section, or Group 2, that is being highlighted here anyway, is a provision that requires certain notice, procedures and an opportunity for competing bids on the powers of the city to sell, lease, or convey property worth $500 or more. that's a pretty outdated number. It's a pretty outdated process. It would theoretically prevent the city even from selling, fragments of property, back to an adjacent property owner when we vacate a lease. It's kind of cumbersome. It's viewed as kind of unnecessary. And a lot of the terms, for major transactions are heavily negotiated over time. The idea that you would negotiate potentially the sale of a significant city asset, and then before you could consummate that sale, you in effect need to make that property available to somebody else, and consider alternative bids, really isn't practical. And so the thought was this is kind of it's an archaic, provision that can't really be fixed, and the group recommended that it be deleted. Now, that's not to say that people might go, wait a minute, what are you doing? We used to be able to have special notice for when you were selling, property of over $500. So I'm not going to tell you that there might not be some perceived political sensitivity to that, but as a practical matter, as a best practice, matter, that's really kind of an outdated, provision. And so the ultimate conclusion and recommendation was to consider deleting, that section. So, Mr. Chair, I'm done with at least Group 2. I know that took a long time. Group 2 was probably the heaviest of them in terms of the amount of, issues that and the variety of issues that they included or that they were assigned, and had to take up. I would defer to any of the Group 2 members if they wanted to supplement, comment on or correct any of the presentation that they hopefully aren't regretting they deputized me to give.
Now I have a question, because it's so timely. If we were to get rid of that one last section, how would that affect what happened about the discussion last night about possible purchase of Agnew and then trading land and stuff?
That provision wouldn't prevent the city from entering into an elaborate set of, should the council approve, right, going down that path. It wouldn't prevent the city from entering into negotiations and agreeing to a contract, but as a condition to close of any sale, it would have to say, hey, as a condition to close, we need to make this property available to somebody else, and the city could actually accept a bid for somebody else if they offer to pay 5% more. So again, kind of a strange thing to introduce to a complex negotiated transaction. Not that no comment on the decision made by the council, last night, but that would be an unusual provision that could make it difficult to negotiate with a third party that we wanted to sell property to, if in fact there was a lot of money that needed to be spent to get to a potential closing, and you'd have to say, I'm sorry, there's a provision in my charter that now requires me to offer it to somebody else. It would kind of undermine that negotiation. Would suggest, Mr. Chair, that based on what we talked about earlier, that this might, if the public has any comments on this section, they should invite it to comment on, the Group 2, recommendations. And then I might ask that this group, deliberate and give direction before we get into something else that might distract, us on what they would like brought back, any potential changes or characterizations of things for when this comes back for final consideration.
Excellent ideas. So first, ask for public comment. Is there any member of the public online that would like to comment?
There's no hands raised.
No hands raised. Okay, then we'll bring it back to the committee for discussion. Does anybody want to address any of the topics, clarify things, or give direction to staff to try to update stuff that we haven't already covered? Glenn, you are just so thorough.
So the couple of things that, that came up that might be included in any direction was, whether or not there was a desire to, include the option of modifying the qualifications for the chief of police. I think that was one of the hot button ones that people weren't sure about. And maybe I misperceived that. Maybe there was consensus to have that come back, as part of the recommendation. The other one that I think there was a desire to have some more benchmarking on with a potential option was the provision for which election, if there was a failed appointment, how we refine the language to redefine what forthwith means as to whether or not to give some time period or further definition around special versus general election based on benchmarking. So those were the couple that I thought weren't as clear and might need further direction.
Susan?
Third one was the first discussion around the city parkland.
Oh, sorry. Yes. And that one as well.
Yeah, I know that there was a comment to, if we include it, remove the word material and possibly say any adverse.
Yes. Yep. Thank you. Those three.
The other item related to general elections, you were going to get clarification on a primary, whether that's included or not.
Right. I'm sorry. That last one I said was my attempt to articulate that. Yes, so what the options were for elections and if a primary was a general election. Yep.
Regarding the chief of police powers and duties, I believe the previous charter left that ambiguous. Whereas here you are enumerating them and you're stating outright that the chief is the responsible for the supervision, management, and administration of the department. I believe this is a increase in the authority given to the chief. And my concern is that we're selecting the chief from a very small pool of candidates. And I believe about half of the elections, we had no choice. So I would prefer if this were left as it was, ambiguous, and not enumerate those powers. So we have more flexibility in the future should we need it.
Mr. Chair, if I might, I think that you're jumping ahead to a very significant discussion that will occur at the next meeting, because the thing that was
Item 202.3.
yeah, the thing that was discussed tonight is whether to change the qualifications of the chief of police, not the duties. Yeah, but there was a discussion in the course of that of having alignment with the qualifications and the duties, but that's not part of Group 2's report out. That's a Group 3 report out that you'll get at the next meeting.
See no other comments.
Okay, so
Can we just do that as a direction, or do you need a official motion?
if I were to, it might be worth having a formal motion here. I think what the motion would be is to direct staff to come back with and work with Group 2 to the extent possible, right? Come back with the changes as presented with a modification for the park disposal provision to replace material impact with any impact, to include, at least for now, consideration of adding qualifications, right, to the chief of police, and getting additional information regarding the election, the timing and type of election post-appointment, including whether or not a primary election could be considered a general election, so that final action could be taken on that item. that would be what I think I've gathered the consensus of the group.
I move as Glenn laid out to move along with group 2 and then on to 4.
Is there a second to that motion?
Second.
There's a second. Do I do a roll call vote or we just vote? Roll call vote.
Holly Roberts,
Yes.
Pat Nikolai,
Yes.
Bernard Tansey,
Yes.
Joe Sisinski, Eric Crutchlow,
Yes.
Bert Field,
Yes.
Steve Kelly, Lauren Diamond, Eric Jensen,
Yes.
Mark Beckman,
Yes.
Susan Peters.
Yes.
Thank you.
Thank you, Mr. Chair. Do you want me to keep rolling?
We roll on to group 4.
Group 4. Next slide. Group 4 was the boards and commissions group, composition, powers, and duties of the various boards and commissions. Another active group, 5 meetings, even a 6th meeting. I think we're missing one of the ones here, the May meeting. There was a lot of stakeholder input from this group, including from the Planning Commission, the Parks and Rec Commission, and especially the Board of Library Trustees, who met multiple times on this. And of course, all the city's respective department liaisons, including the city clerk's office, on the various terms and conditions for this Group 4 item. To summarize the recommended changes, and Mr. Chair, we could also take a break if you wanted to take just a couple-minute break before we dive into this one. I'm seeing nods from
I
folks.
think a 5-minute break would be awesome.
5-minute break, okay. Break. Went to 1:15 last night.
Oh, God, please don't beat it. I can't.
See how far. I'll also try to. That. Probably about the same, but I hear your thought process. You're like,
The beatings will continue.
yeah, like. No, I'm.
kicks in at the wrong time.
No, we're not.
I'll be sleeping.
No, we're not. Yeah, we're going at 2 o'clock. We're breaking the record. 1 o'clock.
Provision about removing any, or excuse me, the word material. It just, it creates this, I don't see as many verbs as I used. That's the stop.
Okay, we're going to get back on the record here, and by consensus, we're going to skip Group 4's recommendations, and we'll go to those at next meeting on the 27th, and we're going to jump into the Group 6 recommendations and get those hopefully finished up tonight.
Yeah, very good. Appreciate that thought, Mr. Chair. We'll jump into Group 6, which is starting on slide 24. Group 6 was assigned the fiscal administration and procurement sections of the charter. One of the ones in a lot of respects that cried out for, the most change and potentially substantive update, with one instance in particular we'll get to. This group met a good number of times and was really benefited, I think, greatly from stakeholder input from Public Works Department, Craig Mobeck, the Director of Public Works, and Ken Lee, the Finance Director. I also got input from and was able to pass that along from the city auditor and then Silicon Valley Power that didn't appear directly but was involved in the public works aspects of the analysis for this section. So summarizing the changes, the first set of changes are the ones that the group heard about from the Finance Director Lee. The budget preparation sections, old section 1301, new sections 801.1 and 801.2. The changes really focused on adding language to allow for the current biennial budget process with alternating operating and capital budget approvals. One of the things you've heard a couple of times and are now hearing again, hopefully for the last time, is that the way the city currently budgets doesn't align with how the charter contemplates the budget process. The charter contemplates a single budget every year. And instead, what the city does is it divides its budgeting process up into an operating budget and a capital budget process, and it's done biannually, which is there's a 2-year operating budget and a 2-year capital budget, and they are presented in alternating years. What we do as a city should align with what the budget says, right? And so this is really one of those examples of aligning, with the current practices with the budget language. And it is, not everyone does it this way, but it is a very common practice that I think is supported by current staff and appreciated by the city the city council, because it allows kind of even a more detailed presentation on the operating budget or the capital budget, depending upon which one's, up, than they would be able to give if they had to give the same one every year, right? They can give a very detailed one and project out for 2 years of estimates if they're doing it in a biannual manner. So those are really the extent of the changes in those first couple sections. Budget contents, what goes into the budget. There are a lot of sections in here of really unnecessarily detailed and inaccurate descriptions of what the contents of the budget were. Those are in old sections 1311 through 1314. And what the group talked about is whether those things, need to be there any longer, or instead, can be synthesized into a smaller paragraph. That's what member Lee, he's not a member, honorary member, Director Lee, was recommending, and ultimately what the Group 6 thought made sense. And so there's a lot of sections in the existing charter that were deleted, and then were synthesized into section 600.3, which just, oh, jeez. Thank you, which were synthesized in 801.3 to include a number of different elements. And I'm going to go to 801, 0.3 now. And say that, about eight different sections, maybe 6 different sections have now been boiled down to this description of budget contents. The budget will contain provisions to fund city operations, programs, and services, city facilities and infrastructure improvements, maintenance, and repair, reserve accounts to cover future anticipated and unexpected operational or capital needs, and then such other lawful projects or programs approved by the city council. The most important aspect of this that was talked about at really some significant length by the group was whether or not the charter should include specific standards for the reserves, right? What reserves accounts should there be? And is there an amount or a percentage of the budget that should be included in the charter itself? And there was discussions about that both with Mr. Lee in the room and outside of that. Ultimately, although there is meaningful concerns expressed about how the city has been establishing its reserves and a concern about wanting to be as specific as possible, based on Mr. Lee's professional input, the thought process ended up being that it's hard to establish a standard, in a charter that would need to be revised, by the voters, that really captures every set of economic circumstances or the needs of the city at the time. And so it would be better to, while obviously still requiring reserve accounts, instead leaving it to city council policy making to determine, what the appropriate reserve amounts, should be. There was language added that put some guardrails, around that to make sure that the city council decision about this about what the reserve amounts, right, and accounts should be, would be based on recommendations from the city manager and the finance director regarding best practices, and then based on available funds, right? You might not always have money to put into your reserve accounts depending upon financial circumstances. Sometimes you might have more, than an annual, reserve policy might require. And so the thought was, please include a requirement for reserve accounts, but perhaps by begrudging consensus, don't establish, detailed provisions around what those reserve accounts, should be. So I'll stop there. I have a feeling members of this group might want to comment or add to that.
Sure, my favorite topic. So I think that one of the reasons that this was a very interesting group to be in was because of the examples of what had gone on in the city that we haven't maintained a lot of our significant property, and there weren't sufficient reserves, and it was good to, Director Lee was very good at answering questions about what needs to happen. And while you don't want to necessarily be specific about it, look at it this way. A lot of times when they talk about reserves, they talk about, we'll take 5% of our revenue and put that into reserves for a rainy day fund. Versus things like, I look at it as know all the assets that you have and you have reserve funds for that. I'm not saying that they don't do that today. What I'm saying is the city council has to be responsible to make sure that when we look at what needs to be maintained and the equipment and the assets that we have, that the allocations should be there. They should be projected and even reported on, saying, hey, listen, we were supposed to have this many reserves for training facilities for the police, and we are not maintaining that. And this is how much we're in debt. We found that out recently when they proposed a 600 million bond measure because we were lacking funds. So I think that this is an area that when you look at it, we have to be very careful about what we can say in the charter, but I still think that the city council itself needs to make sure that we are funding and maintaining all the things that we need to do, considering what has happened. It's a bad example that has been set by not just this, I won't blame it on this city council. I will say it's been kicked down the road by several city councils. And now the city council had to address it in the way that I don't want to address it. So reserve funds have a lot of different meanings, and the meaning should, to me, if I can identify it, save for it, and make sure that you don't have to have a bond measure to fix things later on.
Appreciate that. A lot of good discussions around that. I think the inclusion of that provision and the reference to, inputs from professional staff adds value, to what it currently says. The next page talks about budget implementation and amendment provisions. Hopefully these section references are right. Old section 1300, new section 801. There was a lot of work done here, mostly driven by the finance department's desire to have it very clear about what the staff authority is to, make budget modifications, along the way during the year, and what kind of things need to be brought, to the city council, and your ability to carry forward funds. And to the extent a council approval of a budget amendment is required, is 5 votes always required, or there might there be a circumstance where just a simple majority, would be required? And so there's a variety of changes that were made. The language was revised in order to try to use more layman's descriptions of things instead of pure budgeting, nomenclature. And the provisions here, as revised, clarify where the budget amendment requires city council approval, where it would be administered by the city manager, and where the city manager is allowed to make modifications to the budget is if it's within the various department and funds that have already been appropriated. In other words, below the line of what the council approves, the city manager is able to move money, or even department heads are able to move money. I've got money allocated to me, that's a significant amount of money, but how I spend it, within particular line items is something that I'm allowed to do, and the city manager gets to do that as well. And so it makes that clearer than it was as to what the authority would be. It also allows for and expands a little bit the provisions that allow the city professional staff to carry forward funds from one fiscal year to another if there is funding for an approved capital improvement project, right? That either was intended to take multiple years or turns out taking multiple years, or if there's money committed to a multi-year contract. The revisions to this budget would allow those monies to be carried forward to the next year because the council's already approved their use for that purpose without having to bring it back to the council for it to be approved again, right? There's certain things when you go down the path for implementing a capital improvement project or for implementing the terms of a contract where you're counting on those monies. And it would be compromising if in fact the council approved it one minute, but then didn't the next. So it allows for, in those limited circumstances, for the carry forward of funds. It does retain the requirement for council level amendments to the budget. In other words, money taken from one place and moved to another, right? At the high level, not below the line, right? Where it's just within existing funds or departments. Council would need to approve that. And the existing requirement for a 5-vote approval, a supermajority approval is retained. But there's also a provision that modifies that to only a majority approval, where in fact, if the funds are no longer needed for the original purpose, in other words, there's project savings, or where there's actual new revenues that get allocated. For example, if the city gets a grant, right, and wants to, and is getting a grant for a particular purpose, the existing language basically says there needs to be a supermajority vote for that, where the revised language says, no, that's new money that wasn't approved in the first place. We're not changing something the council already did. In effect, they're approving this thing in the first place. So if the city gets new money for a particular purpose, it shouldn't require a supermajority vote of the city council. So these are all things that the finance director in his implementation of the budget kind of wishes, there were, in order to give him, certainty, in order to balance, his administration of the budget, with the council's obviously right and ability to approve things. So those are the changes that are proposed there. I will point out that part of our research on this, because it's pretty typical to have the charters that I've seen, including with the benchmarking, 5 votes for budget amendments. There is for general law cities, that is the requirement, but it is not it is something that charter cities get to decide for themselves. In other words, if our city wanted to just require 4 votes for every budget action, both with the original approval of the budget and the amendment of the budget, we could do that. But the thought is there is a certain check and balance, right? If the council approves something and now you're changing it in a meaningful way from what they approved in the first place, that a supermajority, vote would be required to change that was originally approved in the first place. But some people look at that and they think that's a little bit ironic, because you'd think it would be 5 votes in the first place, and then a minor amendment would be 4. So there's a lot of different thinking around this. Really, the thinking and the changes that were made were driven by the finance department's experience and desire to be able to administer the budget in a more effective way.
When the Peregrine contract passed with 4 votes rather than 5 recently, and the city council suggested that they scrounge around to find the money, it was within this existing authority to move money around within a department, for example, that would allow them to do that.
Yeah, I'm trying to read that. Of course, was a controversial action and subject for as much for citizen concerns about use of data for that contract as it was for parliamentary, procedure reasons. The reason why it required 5 votes is because it was proposing to use monies that hadn't been allocated for that type of purpose. So it was taking money from one place and moving it to another place. Why, even when 5 votes weren't obtained in the end, for that, the contract was approved, but the project was able to proceed was that the city already had money that didn't need to be moved, that it could use to fund that project. And so the actual movement of money, while that was preferred, and was part of the primary recommendation, it actually wasn't necessary under the approved budget that already existed to fund that contract. So I think I'm remembering that correctly, and that's
My
where it ended
question
up.
is the existing allocation of money, the appropriated funds were sufficient if they moved them around under this authority to fund it. My question is, does this authority exist under the current charter to move within departments as opposed?
Yes, to move within, that exists already. Yeah, it just, what the changes do is make it more clear what the dividing line is, using more layman's term language, but also language that the finance department's budget professionals understand as well. Next section is purchase of goods and services. Really not much to talk about here. There was already a provision for this. The only modification there added a provision for the city council policy making or for the city manager and city council policy making to consult with the director of finance. And in the fiscal area, that kind of consultation to make sure policy making is tethered, in the professional person who's who's assigned that responsibility. It was viewed as a good idea and a best practice. Next page is really the kind of the brunt of this item, and where most of the time was spent, both in discussions and in input, and that is the proposed changes to the public works provisions. As you all remember from the initial presentation, because this was identified right from the beginning as something that needed an update, and from the various report outs from Group 6, the existing language in the charter regarding public works is pretty outdated. In a number of respects, one of the most conspicuous ones being that for any public work that cost more than $1,000 was required to go through a formal noticed bid process and was required to have city council approval. Beyond that, not just public works, but any decision to use city public works employees, forces, to perform a public work that was projected to cost $1,000 or more also needed city council approval. And so what that ends up requiring is, and it's mostly Silicon Valley Power, but it's other utilities as well. They've got a lot of employees that can perform public works and do minor projects. Major projects they bid out, but they've got in-house staff to do this. Every time they had a thing they wanted to do that cost more than $1,000, they had to get the city council to approve, that and make a determination about that. They've looked at kind of some benchmarking for that, and over the last, I think, 3 years, they've had like at least 50 or 60 items that had to go to the council to do that. That takes up a lot of staff time, more than you might think, and really kind of slows down their ability to use city, forces in order to perform these functions. So the other thing that the existing charter language didn't include was the ability for the city to do best value procurement for public works, or any other type of alternative procurement process. Traditional public works are procured with the project being designed typically by either in-house city engineers or engineers that they hire. And then once they design that project, that design is put out to bid, and contractors bid on that. And according to our city charter, that bid must be awarded to the lowest responsive the responsible bidder. Not the best bidder, not the most experienced, bidder, the lowest bidder. That can create dynamics where a bidder who might not be the best bidder bids on a public works project. They lowball it, right? And then lo and behold, as they're implementing the project, you had to award the contract to them, you get change orders, right? That you end up having to pay because they've identified things, that they've concluded wasn't in the original scope. So traditional design, build, projects are kind of the standard and work, a lot of the times, and most of the contracts you deal with, right, are good, honorable contractors that, make proposals, and you go about and implement those projects. But there are certain other projects and circumstances where it would make sense to have what's referred to as a best value process, where instead of just automatically awarding, a project to the low bidder, you're evaluating, the quality and experience, of the contractor, and you're potentially awarding a contract to not just the contractor, but to a team of a design professional and a contractor that work together in order to come up with a proposal that, in fact, they would have to ultimately produce at a capped amount. In other words, a guaranteed maximum, price, contract. These alternative procurement mechanisms are frequently used for complicated projects and are viewed as something by our Public Works Department and Public Works professionals as something that can save time and save money and end up with a better, ultimate project that could be value and engineered along the way to manage costs. And so our current charter doesn't allow for any of that. And the thought was, particularly with now a $400 million infrastructure, bond and some complicated projects like building fire stations that are frequently done with design build kind of best value projects, now would be a good time to modify our charter to allow for those types of alternative procurement mechanisms. So there was a lot of presentation about this. Appreciated the Public Works Director coming in and talking about it. I'm hopefully doing a good job of describing, his, professional expertise about how these things work. All of that, with all of that considered, the consensus of the group was to really replace the existing charter language that has these unusually low, limits on things that need to go to council and require formal bidding, with a outline of what a public works procurement ordinance would include, including an appropriate benchmark for what would need to be formally bid, and what where council approval would be required, and a lot of other kind of good elements of checks and balances, including alternative bid practices, that would allow the city to deploy, what are considered to be modern, best practice, best value, procurement mechanisms when the circumstances required. So that's what this slide describes, which is the option A proposal. Don't just adjust the limits, because $1,000 would need to be, increased to $250,000 or $500,000 in order to make sense. And that might have people reacting very adversely, to what you're proposing to do in that regard, and instead take the existing language and contemplate the adoption of an ordinance that would implement all of the details about how public works, by city council approved ordinance.
And
So-
real quick, just to be
Yeah.
clear, we don't budget in compliance with the charter, but our public works are held back by what's missing from the charter. Sorry, hour 3 snark, but.
I think how our current charter is drafted has many more projects formally bid and coming to council for approval than makes sense. So it creates a lot of extra work and slows down, our public works projects. And because it doesn't allow for alternative procurement mechanisms, It does not allow for more efficient and potentially money-saving, alternatives to implementing complicated public works. And so this would, in effect, replace our existing, structure, not traditional bid build, concepts, because we frequently do and would make sense to do that, particularly on things that we do all the time, like road improvements, right? That's not a design build project. It's a fairly straightforward project. There's a lot of contractors that do that work, right? When you bid that out, the low bid, frequently is by a really good, contractor that you can count on to do that work, and you don't need these other procurement mechanisms. So it doesn't replace that. It's just where it makes sense to do the alternative, procurement process, adds an additional public works procurement tool that would now be available to the city council and public works. So that's the description of what was proposed as an alternative to this, which was evaluated, but ultimately determined not to be as good as option A. Option B would have been tinkering, with the existing, language to increase those limits by a specific dollar amount, or, potentially increased by an index, and then adding the alternative procurement. But the thought was this was a better approach and one more likely to be approved by the voters who wouldn't instead be looking at what? You're increasing 1,000 to 250,000. What are you thinking? What are you doing? Right? It might be hard to message around that. It was also pointed out that back in 2000, there was an effort to increase that dollar amount from 1,000 to 50,000, which probably seemed like a lot, back then. And that measure was defeated, by the voters. So the thought that this other approach would probably be better received. And of course, all of the rules about this would still be made in public. They just would be made by, city council ordinance. It's not like, these things would be happen, in a dark room. So any other questions on the public works part?
I think 602.4 is not the right.
Oh, geez. Which one?
I also don't know if
602.4?
802.2.3 is right. I think it's just 802.2.
Oh, it's not 802.2.3?
I'm going.
Now that you guys have been catching these, yeah, Courtney's on top of it. Which one? Okay, that's wrong. Okay. I'm clearly section 8 or something.
So option A is the one we just went through where we don't increase the 1,000 to 250,000.
Right.
Okay, so
Yeah, that's option A. Yeah, option A. And it's detailed in the, obviously in the language itself. New section 802.2. Happy to talk to any of you about it more. You can see it, it really importantly, I think, it contemplates this all being implemented by ordinance, but it's not just any old ordinance, right? The ordinance has to contain these things in it, which are pretty good checks and balances that make sense. The city council retains approval rights over major projects, while minor projects are approved by the city manager, right? And the ordinance will decide what that break point is, right? It could be 250, could be 150, could be 500, whatever the city council ultimately decides. Competitive bid processes for all contracts with formal advertisement for bids and sealed bids required for all major contracts, right? So it doesn't do away with that. It still contemplates it. And it says, in general, except as provided below, the award of contracts shall meet the lowest responsive and responsible bidder. So there's a variety of things in there. I won't read all the rest of them, but are designed to be the framework for a good, thoughtful, kind of ordinance with checks and balances to make sure that it's being done in an appropriate way. Okay.
Glenn?
Yes.
So is the intention that we're going to present option A and option B in our final, or are we going to pick one of those?
That is up to you. I think it would be a little, it's up to you. I think it can be approached either way. That would be a good thing for discussion and direction.
We had this discussion in the subgroup too. It's like, keep it simple. Be too many options, you wind up like everybody starts coming up with third, fourth, fifth options. So I think if we agree that option A is the right one to do, I would suggest that that's what we pick and leave it at that, because guaranteed there will be questions and there will be, let's do it this way instead.
Yeah, I think you need to identify it as a conceptual alternative, but putting them both in front, may be a lot. All of this is going to be a lot, right? As you can tell from how we're going through it now for the council to absorb and react to, and that might be a good instinct.
I know Group 6 is obviously in favor of option A. Is anybody not in Group 2 opposed to option A?
Or did I not do the option A justice, and do any of the Group 2 people want to speak for it?
Well, I mean, what we were saying is like, okay, change the values, and like, this has already been done. So, and it didn't work out. So it's like, okay, what's a better way of doing it rather than saying, oh, we'll change it to $2,000. Still too low. We're not going to do 50,000 or 250,000, which is probably more in line. But I think I like this because what it does is it tells the city council, you do by ordinance. And if you don't trust your city manager, you can always say, no, I don't like that, what you just did, or we're going to change the thresholds because we've had these problems. But it's dynamic. You don't have to change the charter every time to try and get something like this done, because obviously you don't change the charter very often. It gives the city council the ability to deal with it in real time.
One additional thought, if I might, on that is this is probably a level 3 change. As opposed to other level 3 changes, though, where you're like, oh, if it's level 3, do you even, is it even worth putting separately on the ballot? This one would be worth putting separately on the ballot. This could potentially add a lot of value. And if for some reason the council said, hey, I don't want to risk the rest of the, of this amendment, but I definitely want this, a good case can be made that, hey, let's put the comprehensive one, on the ballot, but let's put this one on, just separately because we want this, no matter what. So that might be a reason to go all the way, right? If you're going to put it separately, you might as well get the full, thing that you want, in the amendment. But that's strategic political thinking that ultimately the council will think about, and decide on as they contemplate what's the best thing to put in front of the voters and what's the best way in order to do that. If nothing more on that, we'll go to the audit requirements. This is pretty straightforward. Old section, I think 1319, and new section, I think 803. The changes here eliminate language suggesting that each city employee gets audited. It's a weird sentence that says that we shall audit, the finances of the city, and, each city, employee, director, and everything else. That's not how audits are done. You don't audit each individual person's, conduct, and it seems to suggest that. So that is eliminated. That's not the kind of audit that's being contemplated here. So it eliminates that language. It also imposes, a standard on the audit. It should be done in accordance with generally accepted auditing and accounting principles applied to government agencies. That language and concept came from Ken's group. There's a lot of talk about, should we be, should it be this standard? Should it be that standard? Should it be that standard? Again, the thinking is it's the charter, right? Those standards could change. The concept of auditing standards and accounting standards even is different from a private agency, a private company to a government agency, and there are particular, accounting and audit standards that apply to government agencies. And so, being at least that specific, but being otherwise general, Ken Lee was comfortable with that as being the appropriate standard. And finally, the concept of an audit being, presented to the city council was included in there, but it didn't contemplate what currently happens and what ought to happen and is a best practice is that there's a audit committee that's set up. And so this now contemplates that the report out goes through the audit committee ultimately to the city council. And so that existing best practices structure is now memorialized in this version of that. Special rules for utilities expenditure and revenues. Old section 1320, new section 804, correct? It eliminates some outdated details for how utility monies could be expended under both state law that requires the utilities to account for their revenues in a way to assure that they're not charging rates that are higher than costs. There are some special rules that apply to accounting for utility enterprises. This preserves that in accordance with applicable law, but not in the language that's described in the charter, because the language that's described in the charter is not accurate and is unnecessarily detailed. And so the details were eliminated and it refers instead to as required by law. And that was suggested by Ken and his group. There also were some modifications, just for clarity, on the very important provision that's in our charter and needs to be in our charter. It needs to be voter approved. The language that provides for a 5% transfer of utility gross receipts to the general fund now makes it clear that those monies can be used for general fund, purposes, where it was more vague than it should have been in the past. As a lot of you are familiar, while this charge applies to all utilities, it's Silicon Valley Power that generates so much revenue from this. It's now approaching $35+ million a year that our general fund gets from this. So it's an important source of revenue. It needs to be in the charter and voter approved because it could be characterized and treated as a tax, even though it's built into the rate. And so this is an important thing to both preserve and to make sure is worded the right way. It doesn't propose to increase the amount or decrease the amount or make any other material change.
Please go ahead and get your sneeze out of the way. I just wanted to point out a small nitpick in 803.1.
Thank you.
We have a generally accepted auditing and accounting principles. And then in 801.3, we have reference to applicable government accounting standards. I don't know if those are intended to be the same thing or if one refers to the other.
That's a good comment. I'll make sure there's uniform references. One is purposely auditing and accounting because it's an audit and there's different standards for audits. But give me the other section again, 803.1 and 801.3. Okay. Yeah, I'll look at those. They should say the same thing. Yeah, appreciate that. Finance and Tax Authority. This is very wonky. It was reviewed by two outside counsels, both our bond counsel and a lawyer that we have advise us on various financing things to, in effect, clean up this language, to give the city all of the authority that a charter city can have in order to impose taxes, impose fees, impose assessments, and issue debt, but without throwing out any clearly conscious, purposeful limitations in the charter on our ability to do that. And so I think a balance was struck here. There was some outdated language that inaccurately summarized state law and the rules that used to be standard rules to apply to revenue bonds that our bond counsel has had to work around. And instead of issuing conventional revenue bonds, he's had to issue certificates of participation, which gets you the same place, but it's a more complicated, financing that costs you more with respect to utilities, financing. And we do a lot of utilities financing because of how expensive SVP's things are. And so you'll see in this section that we deleted a lot of sections, right, that just were super detailed. Frankly, back before there was a lot of state laws in place, both in the Constitution and otherwise, that regulated that in a more detailed way. So we're in effect modernizing our charter by eliminating the, pre-state law, enactments and just having it be in compliance now, with state law. As I pointed out, it also retains important things. One of them is the existing limit on bonded indebtedness is now included in that. It's limited to 15% of the total assessed value of city real and personal property. We did some cleanup language in this section, but it doesn't change the essence of that limit on the city's ability to issue debt relative to the value of its assets. We also include and even clarify and update express rights and requirements for voter approval of any taxes, fees, or debts that require voter approval under state law. That's pretty clearly embedded in the Constitution. And that provision is retained with its own heading so that voters know, hey, we're making some changes here, but none of this is intended to kind of take anything away, from your ability to vote on things that require your vote. Finally, yay. There's a quirky provision in the charter that talks about the limit on the city to finance nuclear facilities. The current language in section 1321E in effect prohibits financing of a nuclear power plant or any interest therein unless approved by the voters. This was enacted in 1981. When was 3 Mile Island? Oh, I don't know. And there may have been anti kind of nuclear, sentiment back then. I haven't done a lot of detailed conversations with SVP, about this, but no one's proposing to build a nuclear power plant, right, in Santa Clara. But the idea that as nuclear power might get more, prominent and available, that SVP might not be useful for them to enter into a contract, to acquire an interest in a nuclear power, facility, and that they would, depending upon the cost of that, might want to finance that. This is kind of an unusual, almost, maybe dated, right, for its time, restriction on SVP's ability to have an ownership in nuclear, in a nuclear facility. Not in Santa Clara, right? Anywhere, because it doesn't say that. So could this be changed, or is it radioactive?
1979.
Thank
when
you.
it happened.
Was it? Yeah, 3 Mile Island, 1979. So, I mean, excuse my goofy pun or whatever it was. This is one of those things, right, that you look at, you're like, that doesn't make sense. We should change that. And then you change it and the reaction might be, what are you doing? Are you building a nuclear power plant, right? Are you trying to build a plant, in Santa Clara? I can see that being a reaction to people, if it was changed like this. And so it's tendered as something that, would make sense to modify. Would it be worth having it be its own measure? I don't know. Should it be identified maybe and tendered to the council for their sentiment, and to see what they think about it? That's up to you guys, as the arbiters of, what it makes sense for this group to recommend, or what might, again, be a third rail. Even if it seems to make sense, right, as you talk about it, the public perception of it might be different. And so leaving that for group discussion and or questions.
Comment.
your wisdom before and saying, if it isn't a problem that needs to be fixed, do we need to fix it? I think that in this case, why open up something that's going to be potentially contentious and then take away from the rest of the work that we're trying to do and get things done? I think if there was something in front of us right now where somebody said, hey, we want to do this and such, I think that's the appropriate time. And in the end, it says, hey, the voters have to approve it. So I think if we do go nuclear for some reason, great, let's do it when we have that in front of us. Otherwise, if we bring attention to this, it could detract from the rest of the things that we're trying to do.
That's fair. And Glenn, just to clarify, you've read it and you've read it with outside counsel. This can't be read as financing one inside of Santa Clara, right? The existing language such that we would be able to finance one outside of Santa Clara. You're confident in the read?
The current language doesn't talk about inside or outside Santa Clara. It just says we can't finance a nuclear power plant or any interest in a nuclear power plant. It isn't even place specific. In theory, again, not contradicting Member Crutchlow's comment, because I agree with him. I mean, that's a reasonable place to end up with. Yeah, and particularly when you quote me, it must be reasonable. But in theory, if you were going to tweak it, right, and say that city can't, finance any nuclear power plant within, or near, the city of Santa Clara, in theory, you could say that, but it's still, right, that's sensitive of an issue. I don't know if that fixes it. If someone's going to react adversely to it, I don't know that fixes it.
Problems with state and federal anyway. So, I mean, there's, if it ain't broke, don't fix it. And I think that, it also, if you want to play hacker on this, small nuclear power plants, SMRs, which are the big thing that people talk about today, potentially, I don't have to finance it. I'm just going to buy it. Buy the damn thing, make 300 megawatts, and I'm not financing it technically. Well, I don't think the voters would appreciate that either. But again, I think we're stepping on we're putting out a landmine we don't need to put out.
Fair enough. And yeah, I'm glad of you volunteering your backyard. I think that makes sense to me.
Yeah, and if I could, if one due diligence thing I might do before before this comes back for your final action, I'll re-inquire with SVP to see if there's anything there that, oh my gosh, yeah, nuclear is happening. And yes, we really need and want to do that now. Yes, that's going to be important to us to getting a competitive advantage. I'll get some, additional input on that, but I appreciate your perspective. It may just be too much.
I would say that's great. Definitely do that. I would also say that if they are looking at doing it, let's not make this the touchstone for them to start that process. Let's let them bring it out on their own and such, because I think that it just, again, there's so much that we're changing. Less is better.
I'd just like to add that there's, I believe there's nothing preventing SVP from buying electrical power from a nuclear facility. It's just that they can't have ownership of it. And as such, I don't think it's very limiting. So they could still buy power from a small modular reactor in Utah if they want to.
Well, I was thinking about buying one in my backyard.
Yeah. Well, you never know. That might be going in all the data centers. So
it's for my ADUs.
Yeah, it's funny. I think you're all right. I think the language is very specific, right, to financing of a nuclear power plant or interest therein. It doesn't say you can't buy nuclear power. It doesn't say you can't buy a nuclear power plant. So it's a little, if that's what the thought was, to try to prevent any involvement for the city in nuclear power, it wasn't drafted very.
Yeah, in 81, if you were going to finance you would have to finance a nuclear power plant. There's no way you could buy one.
Yeah.
That would be, you'd still be paying that off.
Very good. So if there's any other questions or comments from Group 6 that they want to add, Chair, then you could consider going to the public for.
We asked the public, I'm sure there's hundreds of people online right now, if they would like to make a comment. on this topic? Okay, so there's no public comment. So for feedback, I think the one major topic is the proposal A or proposal B. So maybe if somebody from group 6 wanted to make a motion to put forward, that would be helpful.
Make a motion that we put forward option A and not option B.
Third.
There's a motion and a second. Any discussion on that?
Chair, can I recommend maybe if there's, you could combine that so as not to make two, is everything else okay too? So you could say recommend we proceed with all language as presented, including option A.
Maker of the motion, does that sound good?
I accept the friendly amendment to the motion as.
And the second, excellent. Should we do a roll call vote?
Roll call.
Pat Nikolai,
Yes.
Bernard Tanzi,
Yes.
Joe Sisinski,
Yes.
Eric Crutchlow,
Yes.
Bert Field,
Yes.
Steve Kelly, Lauren Diamond, Eric Jensen,
Yes.
Mark Beckman,
Yes.
Susan Peters.
Yes.
Okay, then I guess we can move to the last item on the agenda. Last item on the agenda is staff presentation and solicitation of committee input and/or direction regarding process for creating and contents of the committee's final report and recommendation to the city council for the charter project. 2, possible need for and action on scheduling one or more additional committee meetings to complete the charter project work plan.
Thank you, Mr. Chair. The process for completing and contents of final report and recommendation to the city council, I think we need to defer that discussion to a future meeting. We've had a few discussions along those lines with a couple of the committees about how that process might work, but I honestly haven't had the opportunity to give that any further thought. I'm saying defer it only because I don't have a presentation, but that doesn't mean this group can't discuss if you've got ideas about what goes into the report, and how that will be presented. I just don't have any great insights, at this point, other than the fact that I think we need a very detailed report, that I've already started framing out some of the contents of that. Looking at the Sunnyvale example, which I thought was very thoughtful, and well done, and understand that by necessity, with my kind of understanding of all the different elements of this, I will need to play a prominent role, in the presentation of that. But I think the presentation would only be enhanced, right, by ownership, and involvement of the groups, in adding, to that presentation and playing a role, in describing the thought process, and how you all ended up where you ended up with your recommendation. So those are just my general observations, but I don't have too much to say beyond that.
I have a question about that. How much time do you think you'll have to actually figure that out? So let's say we have our final draft, right? When do you think we'll have our final draft, if you can kind of make a guesstimate? And how much time do you think you'll have to actually sit and figure out a way to present it to council?
Not a lot.
A day, a week?
No, more than that. I mean, I at this point, this far along, we probably need to start roughing out what the report looks like, anyway, with the elements of it that there's already some consensus and direction on. It probably makes sense to, in my thinking about it, to the extent this group has bandwidth, that maybe set up and we could do this at the next meeting. It's probably not agendized properly for this meeting, some form of ad hoc subcommittee, the report committee, to help with the architecture, in preparation and potentially presentation of elements of the report. And so when I was deferring it until May 27th, that was one of the thoughts I had, right? To, formally enlist the support of a subgroup of this, committee. Because you're all looking for still more to do, with this in order to facilitate, that production. But, yeah, there's not a lot of time, between now and when this needs to go. The next slide kind of gets at that a little bit, and it might make sense for me to go through, this in order to inform, your thinking about that process. As I mentioned briefly at the beginning of our presentation, this is how it's currently kind of laid out for city council consideration and action. We are targeting an initial presentation to the city council on June 9th in a workshop setting. In other words, presentation with council questions and preliminary feedback, but no action, right? At least to get it out in front of them and familiarize themselves. The report wouldn't necessarily need to be done, by then, the formal report and recommendation, but at least the document, right, in substantially final form, if not final form, would be good to present, to them. And to the public, right, with some even more formal, big leagues, city council level, socialization and familiarity, with the draft. So the next presentation, and ideally with the formal recommendation and report, would be presented to the city council at a special meeting, which we just got scheduled this morning for June 15th, 2026. They wouldn't necessarily take action there either. And in fact, I doubt they would, but they'd have had a time right after the study session and, with a copy of the report, by then to have further thoughts, about this. And maybe even give a, go, no go on, how much of this they'd be prepared to finalize, and even consider recommending, for the upcoming ballot measure. And then an additional presentation may be necessary in early July to them, depending upon the feedback, that we get from them in those first two sessions. But no matter what, unless they're going to schedule a meeting during their summer recess, which I handicap in the highly unlikely, area, they would need to act on really every element of this. That's the actual proposed charter changes and all the different pieces of what goes into putting a ballot measure, on the ballot by their last meeting of July 14th in 2026. If you remember that all of that needs to be finalized and submitted to the registrar of voters. I think the date this year is August 7th or 8th. I forget which one, but in that time frame, in early August, in order for them to do all that they need to do in order to make sure it gets on the ballot. So pretty compressed time frame. And this is how it maps out. The scheduling requirements for the Charter Review Committee on the next, page. We've already got scheduled the May 27th meeting to hopefully, if not finish, come close to finishing the report outs. If all of you look at the materials, right, and even the PowerPoint on the other group, and we'll try to get it out, the rest of it out front of you. Maybe I can be a little less exasperating and detailed, in my presentation of all those elements to it. But depending upon how that goes, you may need another CRC meeting in June prior to the June 9th City Council presentation in order to finalize, your recommendation. And I think that's likely given how long it took, for us to go through that. Courtney had been polling and can give you maybe an update now on what polling she might have or might need to do in order to check what the availability of this group would be, to reconvene for hopefully what would be the last, meeting necessary in order for you to develop your recommendation and maybe assign, to any subcommittee you might have decided to create, the responsibility to get the report finalized and over the line. And so that's how it maps out, Mr. Chair, and I'm obviously open to discussion and direction as the committee may see fit.
See a lot of tired faces and no comments.
No, I think that you did a good job at outlining what's needed. I think the key is what's the outline of the report and how do you present this? Because you just say, here's the old one, here's the new one. It's going to be a lot of questions, right? And we know that. So I'm thinking that at least coming up with what does that look like? How would you, if you were on city council, how would you want to consume this? Because this is reading like one of those Dostoevsky books. It's huge and it's really hard to figure out who's killing who. But I think, for me, like a couple of my thoughts, like number one, have a prefix that goes in like, hey, here is our philosophy in going through this. One, clean it up, make sure it lines up. Two, things that we're changing, we came up with these different levels, 1, 2, 3, 4. And we are identifying, these are the things that we feel that, our blow should be easy. These are the ones like, yeah, we know that this should probably be taken out as a separate ballot. At least give them the philosophy that we went through, because that's going to probably be one of the questions they will ask. And then how do you put this in at a high level? And what's the 30, I can't quite see what a 30,000 view would be to showing all this. But I think it needs some kind of overview and preface to be able to explain some of the things that we did and why. But I think that's the key right now is what should the format of that presentation be and how can we best help you to get there?
Yes, both in written and verbal form.
Your verbal's fine. You explain things great.
I know one of the things we have to do is go to public comment. Does anybody in the public want to discuss the scheduling requirements? Shocking.
Hey, people are online. And one of them is probably my wife. She wants to know where I am.
Anything else we needed to accomplish tonight before we adjourn to the 27th? Or we'll discuss group 4 and
Yeah, other than appetite and availability for a June meeting, I think is probably a good conversation to have. Or if you just want, to the extent we think we are likely to need the meeting, and I think we're likely to need the meeting, just ask or need a poll, you for nights where we're available and we can find a space to meet.
June
It
20,
could be
I'm
a-
sorry, May 27th is perfect. So let's just book it.
Yeah, so May 27th, we're booked, and that's going to be in city council. The trick for that might be, this was pretty grueling. I can do better in making my presentation tighter. Sorry, I produced the report and wasn't able to spin through it even once before I had to, present it to you. So I could probably be tighter, the next time, this comes to you to get through more, but we might need a meaningfully longer meeting on the 27th, right? In order to even get to a place where we only need one more meeting, in order to complete it. So I guess I might adjust expectations for the group as torturous as this was. We might need another torturous plus, version of this. And again, people's availability, for one more round, in order to, be prepared for the engagement with the city council. Yeah.
we need a motion to have the city provide us coffee at the 27th meeting.
Yeah, I'm sorry. I've been one of the logistics things. I didn't even bring water for myself, right? That's how, attentive I are. I think I brought snacks, at the first meeting, and then after that, it's all fallen by the wayside.
That would be very
Yeah,
good.
that's right. So sounds like it just makes sense for Courtney to poll folks, right? And to assemble as many of you as possible, for a meeting in early June, in a location we can track down. And I just want to thank, before we leave, library, director and her assistant. I didn't know they had to stay the whole time. And maybe she told me. But after Patty being there along with the rest of us until the wee hours, to have her and her staff set this up for us and host us in a different, location. Super appreciative of that support. So.
The late.
No, fining is no longer a thing for the libraries. Yeah.
I can start coming back.
Yeah, except for Cydia. Yeah.
Well, then if we're going to end this meeting, I do have to say, because maybe my wife is one of the people watching. It is my 20th wedding anniversary tonight.
Wow. Very good.
And I thought, what better way to spend it than at a CRC meeting? So
Yes.
we shall see if I make it to 21 after this.
Yeah, I was going to say it might be now at risk.
But if she is watching, I love you very much. Oh,
You can watch the recording.
I will make a recording available.
Very good.
Meeting adjourned. Thank you.
Motion adjourned.
Thank you for coming. Thank you for going back to back and coming after that. Uh-huh. You want, is a PDF okay, or do you need to?